And as per dates will be given as per available time slot. Only those matters which require tomorrow may come in. Other matters you give it, it will come. Kudi. It all will come in terms of seniority. Correct. All memos that have been taken will come according to seniority. So 5 or 10 every day, we'll put it. ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ನಾಳೆ ಕಾಯಕ್ಕಾಗಲ್ಲ ಅಂದ್ರೆ ಅಂತದ್ ಮಾತ್ರ ಮೆನ್ಷನ್ ಮಾಡಬಹುದು. ರೆಸ್ಟ್ ವಿಲ್ ಕಮ್. ಜಸ್ಟ್ 1 minute.
Page number 2, 811. Page number 3, 216. Page number 4, 7 to 18. Page number 6, 22 to 27.
Yes. You appear for? You have to inform the other side. Next time you have to inform in advance. It's a review petition. Review petition is reach. Correct. Reach adag I will accommodate. I'll make a note of it. Fridays ಮಾತ್ರ review petition. ಇದು 2020 ಅಲ್ವಾ? You have to inform the other side because except Fridays, this review petition will not come on other days.
Serial number 52, my lord.
Just wait.
Serial number.
So inform the other side and then inform the court. Next Friday and then. Or opidre next Friday.
Serial number 52, my lord. Kindly granted 1 week time.
Madam, will you please wait? I will file a memo. Memo could. The petitioner files a memo. In light of the memo, petition is dismissed as withdrawn. Yes. With request made on behalf of the petitioner, list the matter after 2 weeks.
34 to 36.
You appear for? Have you informed the other side? Next time you have to inform in advance. Because the cost title, I put a note. You inform and then inform the court office. 36, But you have to, it's a mood matter. That is a mood matter. ನೋಡಿ ಅವ್ರು ಏನಾದ್ರು ಇದ್ರೆ ಬಂದು ಒಂದು 5 ನಿಮಿಷದಲ್ಲಿ ಬಂದ್ರೆ ನಾನು ಅವ್ರ ಪ್ರೆಸೆನ್ಸ್ ಅಲ್ಲಿ ನಾನು ಅಡ್ಜಸ್ಟ್ ಮಾಡಿ.
57 to 40.
Serial number 52, my lord. Kindly granted 1 week time, my lord.
Number 10, 41. Page number 11. Page number 12, serial number 42 to 47. Page number 13, 48 to 54.
Serial number 52, my lord.
Have you informed the other side?
I informed it.
Have you informed?
Yes, my lord.
That request made on behalf of the petitioner. We list the matter next Friday.
Number 14, 55 and 56. Number 1.
Speakers, from the year 2002 to till date with the respondent number 4.
Speak out notice.
5 to 14.
Speak out notice. Is there any standing counsel for responding 4? Respondent 4 to 14. The petitioner's liberty take out notice by way of hand summons to respondent number 4. But all these are power cognizant. Then they'll let us see. Yes.
My lord, I appear for the petitioner, my lord. Here in this case, my lord, though there is an order of this honorable court, my lord, previously in the annexure E, page 34.
Take out notice.
Yes, my lord, yes.
PG accepts. Now, what about jurisdiction? Tribunal, administrative tribunal?
No, my lord, tribunal, my lord, it's a aided institution, my lord.
Yes, yes. The government advocate is submitting that under 131.
No, my lord, this is a endorsement now issued by the deputy director. Despite the order of this honorable court, my lord, in the previous petition, my lord, as per annexure E. Therefore, my lord, the order that is now passed will have to be considered by this honorable court as to whether such an order could have been made despite the order of this honorable court. The question, this honorable court has decided many such cases, my lord, I will be able to produce. And they have given effect to, my lord, by granting benefits to all others, my lord, in the very same writ petition. The petitioners in the same writ petition, as informed to the petitioner. Only the petitioner at seal number 9, my lord, Rangai Shetty, he is not being extended, my lord, according to him.
Let us. AG accepts notice for respondents 1 to 4.
Macho.
Yes. So you have migrated to Bangalore.
No, I practice here.
So you are appearing
Yes,
there. Okay.
The petitioner, Malad, is a retired employee of the Karnataka State Financial Corporation.
So the clients don't leave you wherever. Huh? Yes.
Privilege of a
So you take out notice. Let us see.
My only submission, Malad, in the meantime, Malad, let them not pass an order of penalty. Malad. That is my only submission.
No, but it's
Government, Malad, ultimately has no jurisdiction, Malad, for 2 reasons. I am an employee of the Karnataka State Financial Corporation. I am governed by the rules of the Karnataka State Financial Corporation, Malad, which I am annexed.
no. Just 1 minute on facts. The inquiry at an earlier point was concluded.
Now you should get that. I didn't understand. Except if it is without jurisdiction, only exception that I made out. If it is without jurisdiction, I have made out of 4 exceptions. All of them before you write it from the first exception that it is without jurisdiction. The government, I am not an employee of government. If I was an employee of government, I would go to the tribunal. I am not an employee of the tribunal. I am not an employee of the government at all. Government has no. The Karnataka State Financial Corporation will not have to take over any action against me. If the provisions of the Karnataka State Financial Corporation permit continuation of inquiry after retirement.
So you are now that last week, yesterday we passed those orders. That same logic may apply in this case also. No, correct. No, that may be. So that may be so, but if the division bench has held that entrustment can be only by that authority, then how you can say that you can continue with this? Now, even at this stage, the
Order of entrustment as well as the second
no, just 1 minute. Now that division bench judgment. Page.
Following that,
So you have saved a tree. Page 190. So what do you say now? Same logic, sir.
You can see, like, this is the second show cause notice that we are now challenged.
Correct.
Take advantage of that.
No, what advantage? That is the law now. Until the division bench order is stayed or is altered, page.
226 is a division bench interim order.
That is 30%.
Yes, Sandeep and all the other interim orders are running.
That Sandeep is decided finally.
So it is still pending.
Huh?
It is still pending. Whatever is based on that judgment, many of the restrictions have been filed by this court. This submission is allowed. In the KSFC employee, government has
How do you say? How do you say that the division bench judgment will not apply to KSFC? Now, if KSFC, also, even if it adopts the government regulations, still KSFC is the authority which has to pass the order.
that is now the judgment has made this submission. Many of the cases.
So, Prithvi's clients are happy. What? Correct. You point out if there is anything. I don't want to give relief so easily to his clients.
But many of the cases, like this 2020 case, whatever judgment, based on that, at least there is one cutoff date. Many of the cases from 2017, they are getting free by this the judgment of this court.
So you move the writ appeal and see what you can do. Now we'll have to give. Now they are entitled for relief because court has held it is without jurisdiction.
That is there, whatever case, without jurisdiction.
So you move the correct. Now we can't KSFC, BBMP, all of them will claim the same relief. Let us see. But you have to now move the division bench. Now see at the very fag end of the inquiry, they are getting relief because of what the division bench has held.
The other matter, the petition hearing was 36. I have told there in the petitioner who is working in the BBMP employee, 36-year engineer, committing so much of irregularities and.
Correct. Now everything has been accordance with law. Procedure, that's all. We are on the procedural correctness. Anyhow, you must move the division bench. Now only on that ground we'll keep it in abeyance, not on any other ground. Page.
And now may I make this suggestion?
Yes.
Promotion and other aspects will not arise. Only so far as penalty, they not impose penalty as the.
That may I, the second show cause notice is issued on 2020. And now the final order is also.
Made a specific statement, it was served later. The document.
He has to give a reply to second show cause notice. Then let him file his, because now that he is already retired, let him file his reply, we pass the number of his order.
What order can you pass now? Till that legal position is clarified, how you can continue? Will permit him to furnish reply, but don't pass any order on penalty.
On final.
Let him, he'll file the reply to the second show cause notice. But the passing of penalty will have to be stayed pending this. Now, insofar as any other KSFC employee, any order? No.
As of now,
BBMP.
KSFC, there is no, it's the first petition.
Correct. But
This is the first petition of KSFC.
correct. Many more will follow. Now, there is no difference between KSFC or BBMP.
There is one difference.
Yeah.
So far as ARIDL, the TCA which were applicable to governments are like adopted for ARIT. So for an ASS is standard, I have my own rules. They are not adopted TCA at all. Under my own regulations, because there is no provision for interest at all. As standard, they will have followed my own set of rules and regulations.
Now, apart from that, even let's assume that you adopt. Even if it is adopted, in that so the investment must be made by you,
From
whether
the
you
managing director.
adopt or not. The petitioner has challenged the validity of the proceedings initiated against him, contending that the entrustment is entrustment by the government is impermissible, as the petitioner's employer, being the KSFC, is governed by Karnataka State Financial Corporation Services Classification, Control and Appeal Rules, 2003. Reliance is based on the judgment in the case of RF Uday Davar versus State of Karnataka and others in WA 634 of 2021, while contending that the entrustment is to be made only by the employer, isn't it? And not by the state. Subject to further consideration, the respondent authorities, though are permitted to proceed with the inquiry, are restrained from passing any order of penalty. AGA accepts notice for the first respondent. Lokayukta Venkesh Arbati is directed to accept notice for respondent 3 and 4. KSFC directed to accept notice for the second respondent. Now you see what is to be done to the take it seriously, because batches will come. Yes.
Have called in concern.
Take out notice. Take out.
The reason is, Lord, there was never a post of loaders and cleaners in the entire.
No ex parte order. To take out notice, we'll care. Now, this unless it is against law, we can't interfere so easily with a he accepts notice for respondent. One for the respondents. Consideration of interim prayers. This the matter. Next week, take instruction.
There was no
They have come late. That's all I think.
6/5 is the date of.
We'll have it on Monday. Have a look at it. No, Monday, no. Monday we can't.
Last date is 6/2022.
Huh?
Last date is 6/2022.
Let us see. We'll have it on 7th. We'll have it on 8th. We look into it. If any ground is made out, then we'll see what is to be done. List the matter on 8th. So who's the employer? Who's the employer? Now, how can you keep a person in suspension for more than 2 years? Now, however, now what I'm saying that suspension is like bail proceedings. It cannot be a punishment. It's only in the interregnum till inquiry started, etc. So even if you don't like his client's case, you can't shut him out like that.
Karnataka Pradesh Krishi Samaja.
Huh?
Samaja is not a government connection, my lord. He might be official secretary, but it is Karnataka Pradesh Krishi Samaja.
No, it's so the point they're raising is whether there's an alternative remedy.
Under the cooperative society,
Whether whether no, correct.
then they have to file other
But under section 25 of the Societies Registration Act, whether you have a remedy, you will have to check.
The official respondent to the guideline of the that is the reason why
So look into it now. We'll consider whether
it comes as a department that is also not work to me because it is.
you find out.
The official joint director, Department of Agriculture made as a party.
Who's the employer now? But we are only at the point that if it is a society, then under section 25, you may have to go before the registrar of the societies. Now we'll have it on 8th to take preliminary instructions. Also on the ground, now the suspension order is in force for more than and he's not being paid. He's not being paid the. From that you find out later. AG accepts notice for the respondent. It's the matter on 8th. AG accepts notice for the respondent. This is the matter week after next. Take out notice. Okay. Both you can accept notice. Food and Civil Supplies Corporation.
Corporation, council appearing.
Learned Council, GB Nandish Gowda. KB Mundi. Learned counsel H.M. Muralidhar is directed to accept notice for the respondents. It's under the
verify the stage of the trial. That prosecution side not totally good. The accused fellow counsel filed an application for 300 levels here, but recalling further cross examination of team. Recall again.
so it goes back to the evidence stage.
But IO ಮತ್ತೆ IO ಮತ್ತೆ doctor pass ಆಗೋದು. On the request of the accused fellow, the trial court recall the other witnesses.
Okay, let us see. What are the facts? No, POCSO Act, isn't it? The notice has gone to the victim, is it? Dekilva? Huh?
That mother of the victim, Basama, respondent over it.
Okay. Yes, what are the facts?
And they went to Andhra Malar and they stayed for 90 days in one rented house Malar, and thereafter Malar, by seeing the social media account of the Krishna Malar, the victim got to know that he already got married and have a kid Malar, and thereafter she wanted to the parents Malar, and thereafter Malar, the respondent to be surrendered to the Andhra, and on 19/7/2019 Malar, he was surrendered Malar.
19/7? Yes.
Person from data forest Malar is initially custody Malar, the victim and the complainant, the victim mother Malar is initially a missing subject was Rag Malar, suspecting directly the Krishna Malar. And thereafter Malar, the examination of victim and mother Malar, and even the cross examination of the
examination of victim as CW.
CW1 Malar is victim.
CW1.
CW1, CW2 is the victim Malar.
PW1. She is the victim. She has been examined and cross-examined.
When I came for the Malar, I have find the 311 application for further loss of and the application has been available.
No, at least the victim's cross-examination was complete. Now, we'll adjourn the matter. Once the victim's cross-examination is complete, I'll consider it.
Case number 38 Malar is produced. My learned friend is produced for deposition of PW1 victim.
No, correct. What are
Support the case of the past.
correct? We can't pass judgment in bail proceedings. So if at least the victims is completed, then we'll consider it. Because most of the other witnesses, you make a list of who are the witnesses who have been examined, who are still to be examined, who are the main witnesses of the prosecution. You also find out who are the main witnesses of the prosecution. If substantially
In this case, particular case, we support the prosecution. Medical examination. At the time of the medical examination, doctor is also support the blood on the basis of material available on the medical support the case of the prosecution. But the victim is blood as per the evidence. Victim is probably supported the case of the prosecution.
So my question is, let's accept everything, but still you cannot pass a judgment in bail proceedings. That finally If he has to go, he'll go after sentencing. Let us see, you find out who are the witnesses who have been, you make a list. Who are the witnesses who have been examined, who remain to be examined, and you finish cross-examination of PW1. So when do you want it? 2 weeks ago, date. It's the matter on 17. 24th. You advance and finish PW1's at least cross-exam. Then we'll see what is to be done. So you finish that, then we'll see what is to be done. Yes. Because of the antecedents. Just read it.
ಆರೋಪಿ ಬಾಬು ಪಾಯಲ್ 35 ಈ ಕೆಳಕಂಡ ಪ್ರಕರಣವು ದಾಖಲಾಗಿದೆ. ಈತನ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಜಾಮೀನು ಪಡೆದುಕೊಂಡು ಬಿಡುಗಡೆಯಾದ ಮೇಲ್ಕಂಡ ಪ್ರಕರಣಗಳ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಜಾಮೀನು ಆದೇಶ ಆದ್ದರಿಂದ ಈತನು ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಜಾಮೀನು ಪಡೆದುಕೊಂಡು ಬಿಡುಗಡೆಯಾದ ಮಾನ್ಯ ನ್ಯಾಯಾಲಯದ ಜಾಮೀನು ಆದೇಶ
Yes. But you have a long biodata. You have a long biodata. Or police are fixing you in these cases. Huh? Yes. Page. Page 20. After evidence of CW 2 and 3. Now the CW 2 and 3 are examined and cross-examined. They are the eyewitnesses.
They are eyewitnesses. VW2 is not a witness because as cross-examination reveals the fact that she was not there at the alleged offences that committed. Because pointed out on the last subject, VW2's cross-examination.
So the CW2, it's CW, isn't it?
Page 27. And at page 30, another page.
Paragraph? Yes. Yes. This is CW2. PW2 and CW2 are one and the same. Allah, CW and PW are the same. Numbering. Ah. Yes. Then who is the other witness?
Is the deposition copy of the deposition was carried on 2020. He's the person who was taking the and watching the one experience to the master
Page? Yes. Yes.
ದಿನಾಂಕ 13/1/2020 ನಾವು ನನ್ನ ಮನೆಯಲ್ಲಿ ಟಿವಿ ನೋಡುತ್ತಿದ್ದೆವು. ಆಗ ನಮ್ಮ ಮನೆಯ ಬೆಲ್ ಆಗಿತ್ತು. ಆಗ PW1 ನಮ್ಮ ಮನೆಯ ಕಾಸ ಒಂದು ನಮ್ಮ ಮನೆಯ ಬಾಗಿಲನ್ನು ತೆರೆದಿದ್ದರು. Totally incorrect. She has said before that other bullets are hospital. She was in the hospital. And she is taking care of her child. That is the evidence of PW1, which is page 20 in the around the application. This is
Page?
page 20, PW1.
28 of?
20 of the main divisions.
Yes. Okay. What is the time of the incident? So by then she was not there. Yes.
And this is spoken to by the mother also, PW2.
Yes.
PW1 the time of incident, wife of
So the argument is PW3's evidence doesn't inspire confidence because of this contradiction. Anyhow, that's an argument. Yes.
The rejection case is an observation that the duration of judicial custody is not a ground to enlarge the number of days without considering this. And there are many criminal cases against all of the cases, so it is not every day.
What is the citation you have produced? You produced it along with the.
Along with the on 16/4/2023. That was sent to government entity.
Just yes. 2020. Yes. Yes. Uh-huh. Yes. Order at is Before the trial court itself. Before the trial court itself. This will enlarge him on bail.
I read this blood, I rely upon the blood, para number 2 and 3 of the blood PW2 evidence in chief exam.
PW?
Srimati Afsar.
That is again on merits. Why we should enter into merits?
But in the chief examination, blood, she has categorically blood accepted that the presence of the blood is acute, but it's not a incident. But it is typically stated against this petitioner. But para number 3. Read this one. ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳು ನಮ್ಮ ಮನೆ ಒಳಗಡೆ ಬಂದಾಗ ನನ್ನ ಮಗ ಚಾಸ ಚೂರಿ ಹಾಕುವುದನ್ನು ನನ್ನ ಮಗ ಸಹ ಒಬ್ಬೆ ಹಾಕಿದ್ದಾನೆ. ನಮ್ಮ ಮನೆ ಒಳಗಡೆ ಬಂದಂತ ಇಬ್ಬರು ವ್ಯಕ್ತಿಗಳು ಅಲ್ಲ ಒಂದು ಚೂರಿ ಇದ್ದವು. ಇಲಿಯಾಸ್ ಈತನ ಎದೆಯ ಮೇಲೆ ಚೂರಿ ಹಾಕಿದವನ ಹೆಸರು ದಾವೂದ್ ಇರುತ್ತದೆ. There is a specific word act against this petition.
Who is Ilyas?
Ilyas is a disease. ಇಲಿಯಾಸ್ ಈತನ ಎದೆಯ ಮೇಲೆ ಚೂರಿ ಹಾಕಿದವನ ಹೆಸರು ದಾವೂದ್ ಇರುತ್ತದೆ. ಇಲಿಯಾಸ್ ಈತನ ಕೈಗಳನ್ನು ಬಿಡಿಸಿಕೊಂಡವನ ವ್ಯಕ್ತಿಯ ಹೆಸರು ಸಮೀರ್ ಇರುತ್ತದೆ. Because of blood is heart-wall blood, hands of the blood disease, on that ground blood, ಸಾಕ್ಷಿ ನ್ಯಾಯಾಲಯದ ಮುಂದೆ ಇರುವಂತಹ ಎರಡನೇ ಆರೋಪಿ ಸಮೀರ್ ಈತನನ್ನು ಗುರುತಿಸಿ ಆತನೇ ಇಲಿಯಾಸ್ ಈತನ ಕೈಗಳನ್ನು ಹಿಡಿದುಕೊಂಡಿದ್ದನ್ನು ಹೇಳಿರುತ್ತಾರೆ. ಸಾಕ್ಷಿ ಒಂದನೇ ಆರೋಪಿ ದಾವೂದ್ ಈತನನ್ನು ಬಿಸಿ ಮೂಲಕ ನೋಡಿ ಆತನೇ ಇಲಿಯಾಸ್ ಚೂರಿ ಹಾಕಿದ್ದಾನೆ ಎಂದು ಗುರುತಿಸಿದರು.
So all this is a matter for appreciation in the trial.
But even PW3 is also blood in chief examination. Support the case of the prosecution is stated as eyewitness, not is support the case of the prosecution.
Now we'll enlarge him on bail, but I feel that he should be subjected to some counseling, not as a condition, as only an observation. In looking at the number of cases in which he is involved, some effort must be made to refer him. So correct. I'm on the other issue that the fact is involved in so many cases. He should be referred for some counseling. There are only two things. One, he is being wrongly implicated. That is one possibility. Other possibility is if he is repeatedly involving, he requires some counseling at some experienced hands, so that if any possibility of rectifying some kind of behavior, let him do it. Only in the context of multiple cases against him. Now, can you suggest for counseling? Can you yourself suggest for counseling where we can refer it? He is a resident of? So I'll dictate the order and keep that. So then we'll refer him. Father Muller's Hospital. Let us see if there is some change in the petitioner. Who's accused number? Who's accused number 1? Who has been arranged as accused number 1 in the proceedings in SC 51 of 2000, in the proceedings in 2000 SC 51 of 2019 is seeking to be enlarged on bail in light of his detention pursuant to such proceedings, where complaint has been registered under section 143, 147, 120B, 448, 109, 114, 302, 212, read with 149 of IPC. It is the case that is made out by the prosecution is that on 13/1/2018, the petitioner and another accused, isn't it, knocked on the door of the house of Srimati Afsar, and she opened the door to the petitioner and another. It is the further case of the prosecution that both the accused inquired about Ilyas, and Srimati Afsar told them that he is sleeping in the room. It is stated that the two accused entered the room of Ilyas, and the petitioner stabbed Ilyas while the other accused was holding the hands of the said Ilyas, and the said Ilyas later succumbed to injuries and died. Next. After the investigation is completed and charge sheet has been filed, it is submitted that the petitioner is in custody since February 2018. It is further submitted that accused number 2 has been enlarged on bail as per the order in criminal petition 5157 of 2021, and that petitioner is also entitled to be enlarged on bail. Next. It is submitted that this court, by order dated order dated 11th November 2019, passed in by order dated 30th of July 20, passed in 2020, had deferred, had disposed of the previous petition, wherein the petitioner had sought for being enlarged on bail, while observing that the application of bail could be considered after the evidence of CW2 and 3, who are the eyewitnesses. Next. It is submitted that the evidence of CW2 and 3 is complete, and that there are contradictions in the evidence of CW2 and 3. It is submitted that CW2 evidence, CW2's evidence is cannot be, does not inspire confidence, as CW2 submits that CW1, isn't it?
Says that BW1 openly known, whereas the BW1 person says that on that day at 8 a.m. she was away at a hospital. Among the hospital.
Yes.
Submitted that CW2's evidence does not inspire confidence.
CW2's evidence does not inspire confidence. It is further submitted that evidence of the eyewitnesses is completed, and that appreciation of the evidence of the said witnesses is a matter for trial, and the petitioner is entitled to be enlarged on bail. It is further submitted that in the evidence of PW3, it is submitted that CW1 has opened the door. However, the evidence of CW1 itself is contrary to the said assertion, as CW1 submits that she was at the hospital. She was at Padmavati Hospital at Suratkal at that point of time. Accordingly, it is submitted that the evidence of CW3 within bracket PW3 does not inspire confidence. Next, counsel for the prosecution opposes the grant of bail, submitting that petitioner is involved in several cases. And that by itself should be a ground to reject the application for bail. Next, this further submitted that the witnesses have in fact supported the prosecution. Next, third, both sides. It is to be noted that the petitioner is in custody since February 2018. Admittedly, insofar as the eyewitnesses, as stated by the prosecution, that is CW2 and 3, both have been examined and their cross-examination is also complete. Next. Insofar as the appreciation of evidence of the witnesses is concerned, it would not be appropriate to enter into such appreciation at this stage, as the proceedings for bail cannot be treated to be punitive in nature. The evidence of the witnesses and their appreciation is a matter best left to the trial proceedings. Next, insofar as the contention of the petitioner having been involved in various other cases, the learned HCGP files a report by the police inspector, South Police Station. What is that? Pandeshwara, Mangaluru. And it is submitted that though the petitioner was involved in about 10 cases, he has not violated any of the bail conditions in any of the matters. Further, learned counsel for the petitioner has pointed out that as on date, there are only three cases in which three cases, including the present case, which is pending consideration. Now, the last one is the present case, is it? Yeah. Apart from the present case, that is crime number 7 of 2018, the petitioners involved in only two other cases which are pending trial, that is crime number 423 of 2017 and 424 of 2017, both of which are triable by the magistrate. Next, it is further to be noticed that admittedly that the petitioner has not violated any of the bail conditions, though is stated to have been involved in several cases. Next, the contention that antecedents cannot be the sole factor for rejecting the bail petition is also to be accepted. The petitioner has relied on the judgment of the apex court. What is that citation? Page 75. Party's name? If Prabhakar, another full stop. The taking note that the evidence of the eyewitnesses is complete, that the petitioner has been in custody since February 2018, that though the petitioner is involved in a number of other cases, the police report clearly makes out that the petitioner is not involved, has not violated any of the bail conditions, that the only two other cases still pending against the petitioner in crime 423 of 2017 and 424 of 2017, which are triable by the magistrate, that the present proceedings cannot be construed to be punitive proceedings. Case is made out to enlarge the petitioner on bail. So what are the conditions imposed earlier? The co-accused. Same condition that you give it. The co-accused, whatever conditions are imposed, you give a copy of that. Same conditions will. Before parting, we would observe, looking into the number of cases in which the petitioner has been involved, it would be open for the petitioner's counsel to, in consultation with the family members of the petitioner, if they so consider, to refer the petitioner for counseling. Such observation must not be taken to be an expression as regards the petitioner's behavior, but is made more out of concern as to whether the petitioner could be integrated into the mainstream of society. What is this office objection compliance? Office objection. So this you can comply. Office objections raised are technical in nature and to be complied within 10 days. Yes. Huh? Notice to the victim, is it? Mother of the victim. According? Or has the petitioner already by any chance been enlarged on bail? Await office to put up report as regards notice issued to respondent number 2. List the matter. Relist the matter on 10th. Pass over.
I'm holding for Mr. Ladda on behalf of the petitioner. Notice was issued to the respondents the previous date of the hearing. The same was personally delivered by the petitioners to the respondent number 2 as well. But we have no communication yet whether the respondent number 2 is being represented by an advocate or not.
The ESG directed to accept notice for the first respondent. Copies to be served on the President Solicitor General, Sri Shanti Bhushan. Relist the matter next week.
I'm grateful, my lords.
Yes.
Rectify the documents and sections, my lord. Today itself, the copy needs to be served. But in this case, my lord,
Who served a copy?
I will serve the copy, my lord.
Now have a look at the statement that is filed and come back.
But copy was not received, my lord.
Correct. Take it now.
Yes, I'm ready, my lord. In this case, my lord.
Have you seen the object? How you can be ready without seeing? Relist the matter on 9. Yes. Yes. Two five.
Short for arrears of salary, my lord.
Use the 2 to 5, is it?
I've served a copy. Responded number 4 and 5, my lord, that's all.
AG accepts notice for respondent number 2 and 3. Petitioner is at liberty to take out notice by way of hand summons to respondent 4 and 5. The postal tracking report as regards notice issued to respondent 4 and 5. Notice is issued once or not yet for 4 and 5? You have paid process earlier. Ansati ಹೋಗಿದ್ಯಾ 4 and 5. Petitioner to also pay ಇದು post tracking report kada petitioner to pay process for issuance of to respondent 4.
15, my lord, I appeal for the petition, my lord.
Just 1 minute. Just 1 minute.
Yes.
14. No, you serve it and then move the matter. Yes. Yes.
15, my lord, I appeal for the petition, my lord. Petition, my lord, is a BBMP employee. The order of entrustment is challenged, my lord, on the ground it's bad in law. Similar matters, my lords have granted interim order of stay and also directed the respondent BBMP to consider the case of petitioner for promotion. The order of your lordships, my lord, is at annexure L3, page 102, my lord. 102.
This matter, my lord, incision of fee is already completed, my lord. There is a question of incision of fee. They already prepared the report and government has passed the order, final order. Let them, my lord, show notice to the
Here the penalty is also imposed, is it?
Yes, my lord, penalty is also imposed, my lord. However, it is of no concern at all because entrustment itself is bad in law. Now, my lords may kindly see the division bench order, my lord. Even in that case, my lord, the penalty was imposed. In writ appeal number 634 of 2021, there also, my lord, the penalty was imposed and that came to be stayed. Because I myself, my lord, have appeared before the division bench. It makes no difference, my lord, whether penalty is imposed or not. As long as the entrustment is by an authority which is bad in law, everything subsequent to entrustment goes back.
Now the promotion is in sealed cover or still to be considered, or is
Still to be considered, my lord. There is no sealed cover procedure, my lord, followed in where this petition is concerned.
so the same order as in yesterday's matter?
Please, your lordship, same order as yesterday's. Only the relevant portion of opening of sealed cover has to go. That's
The same order. Yes, same order.
yes.
Office. AG accepts notice.
Filed an IA
One.
for dispensation.
The BBMP will look at same order. Petitioner has filed. IA for dispensing the production of certified copy of each HN in light of the undertaking at paragraph. This is the matter along with the PP number so and so.
Yes, ma'am. Grateful.
I'm for the petitioner, my lord. The petitioners,
Yes.
my lord, had filed IA for impleading, my lord, some of the persons who are likely to be affected by altering the ranking assigned to me in the seniority list of junior.
Issue notice.
My lord,
issue
notice has already been ordered, my lord. They are all being represented and served, my lord. Therefore, the IA has to be allowed, my lord, permitting me to implead them as respondents, my lord.
Yes. Yes.
Connected matter was listed yesterday, my lords. My lords had directed that matter to get listed along with this matter on 8/6. So both the matters can be connected together as my lords had directed yesterday and can be listed on 8/6.
My lord, before
this-
connecting it, my lord, let the IA for impleading be allowed, my lord. I may be permitted to amend the cause title, my lord.
Who appear for the impleading applicants?
Lord, one Nishant AV, my lord.
I appear for proposed respondents.
Yes, we'll allow the application. Then on
Yes.
merits will.
Yes,
The
my lord.
petitioner has filed an application to implead proposed additional respondents as respondent number
4 to 12.
4 to 12.
ತರಕಾರಿಗೆ ಯಾಕೆ ತಗೊಂತೀಯ?
ಈಗ ಒಂದು ಟೈಮ್ ಏನಾದ್ರು ಮಾಡ್ತೀನಿ ಬದನೆಕಾಯಿ ತೊಗೊಂಡು ಏನಾದ್ರು
It is submitted that respondents 4 to 12 would also be affected by any order to be passed in the present matter. Taking note of the submissions made, the application is allowed. The proposed applicants are directed to be arrayed as additional respondents 4 to 12. Amended cause title to be furnished.
Please, my lord.
This the matter along with
21382 of 21, my lord.
21382 of
2021.
2021. The impleading applicants now arrayed as additional respondents to file their statement of objections by the next date. List the matter.
There's already date given, my lord, as next Tuesday.
Yes. List the matter along with 21382 of 2021 on 8.
Much obliged.
Number 17.
Nothing for petitioners, my lord.
Petitioner the corrected matter, but in the first of the matters, we are referring to the contesting respondents. Now, that was the 2016 matter, which was clubbed with another matter, which was disposed of, which is kept below. Now, what had happened? Common order sheet was running, and there were interim orders passed at that point in time in 2015. Subsequently, in 2020, there's a new C&R rules which has come into force, because of which that earlier petition and as well as this petition have become infructuous. But that petition got disposed of. This matter, was listed at 230 or 2 days, because earlier, because of paucity of time, it was not taken up. The main prayer in this petition,
Which has become infructuous.
first matter, that one interim order, is affecting our chance of promotion even today. That interim order also technically does not survive. but the other side is taking advantage of that.
No, just one. 58674 has become infructuous. Point out.
My lord, my seniors Deepak and Abhinav are out of town. Kindly
So that-
grant 2 weeks time, my lord.
That we'll see. Let us see if it has become infructuous or not. Yes.
Please, my lord.
There in the petition, page
Yes.
17 minutes.
Yes.
Issue a writ of order directing respondent number 1 to approve the cadre and recruitment rules of the second respondent corporation and to finalize and give effect to the same pursuant to the draft forwarded on 21/8/2014.
Now this has been notified.
No, after this, there was one more draft, and in March 2020 minutes, the new C&R rules have been notified. This is the immediate reference. I'll just pass on.
So the first prayer does not survive for consideration.
That is, the first prayer does not survive for consideration. And the second and third prayer were consequential in respect of directing the respondent number 2 and 3 to effect promotion to the petitioners from the cadre of assistant engineer to the current vacancies in the cadre of executive engineer based on seniority, and if they are found eligible to be promoted in accordance with the existing Rule 2640 of Karnataka Municipal Corporation rules. Because of the new rules, this also does not survive. Restraining the
So they have just 1 minute. Now they have been promoted, is it?
in terms of the new rules, subsequently, some of the petitioners have been, they were all working as assistant engineers. As per the new rules, even earlier, the scheme was for the promotion to the post of AWE. Before this amendment rule came into force, the promotion was from the cadre of junior engineer and assistant engineer and junior engineer in the ratio of 2:1. That was the dispute then. We were all juniors engineers, they were all assistant engineers. Their claim was only they should be exclusively promoted as assistant executive engineers. Junior engineers should go one step and then come directly to assistant executive engineers. Therefore, my lords, in the draft, there was two different subcadres that were sought to be created, consisting of diploma holders and insofar as degree holders was concerned. Now, my lords, at that point in time, now by virtue of the new rules, what has happened, my lords, there is a subdivision of the cadres. Where, my lords, assistant executive engineer has been subdivided into assistant executive engineer division 1 and division 2. So degree holders of assistant engineers are classified as assistant engineer 1 and they are promoted to assistant engineer AWE 1. And, my lords, junior engineers who are earlier degree or diploma holders, they are promoted as AE 2 and then AWE 2. So because of this new C&R rules, there has been that issue has been sorted out. Now, my lords, pursuant to there were interim orders that were operating when these rules came into force. In violation of this interim order, some promotions were given. Matter went to Supreme Court. Supreme Court directed that everybody should be reverted. Subsequently, BBMP was given permission to seek for modification. When modification application was filed, these new rules also were notified. So therefore, subsequently, an order was passed that they could be promoted to their stream, and we could be promoted to our stream, and the connected matter has been disposed of. Now, what has happened, in this matter, though the order sheet was common, can you see the interim order that was granted in this case? That is on 22/12/2015. 22/12/2015.
stay of further promotion.
Stay further promotion from the cadre of junior engineers or assistant executive engineers who have been promoted from the cadre of junior engineers. Their grievance at that point of time was not that we were now we lost.
So you are saying that this order will have to be clarified as saying that now in light of the amended C&R rules, this stay will not survive.
Stay will not survive. In fact, in the connected mediation, series of orders were passed with a common order sheet running, and it was in fact, this order got clarified subsequently.
Where's the order? This is clarified.
This is not in my respectful submission. It stood clarified, but because in the order sheet the petition is pending, and the order sheet the order is still existing. That is being used against us by the state government not to promote us. Now all I'm seeking for is disposal of this petition or for vacating of this interim order, because the main prayer itself has become infructuous. By virtue of the new rules that came into force, may I pass on the order in the connected matter?
Yes.
That's page 5. So I'll read from the first paragraph itself. When a senior counsel so appearing for the petitioners submits that the petitioners who are admitted to diploma holders joined services of the respondent BBMP and were promoted as junior engineers. On the other hand, the contesting respondents contended that they were directly appointed as assistant engineers, having requisite educational qualifications In this petition, all the private respondents were already working as AWS from 2010. This is concerned with promotion to the post of executive engineer. So, my lords, what had happened? The main controversy was with regard to the junior engineers and assistant engineers and their promotional avenues to AWE. This was an incidental matter which was filed, where they had sought only for notification of the enactment of the new rules. But in the interim order, the interim order says stay of further promotions from the cadre of junior engineers or assistant executive engineers who have been promoted from the cadre of junior engineers. So basically, they are saying whoever is promoted from junior engineer, further promotion should be stayed. That was in the context of the earlier rules in 2015. Now, AWE controversy is resolved, my lords, by virtue of the new rules and the earlier order. In so far as executive engineer, my lords, these new rules are covered. There is no controversy now left out. But this order, because of this order, our promotions, my lords, we are not being promoted because the state government is using this order to.
What do you say, state? Is the new rules. So if you say that everything is going to be governed as per the new rules, then nothing further survives for consideration. So who's objecting for this?
Petitions.
Huh?
They were all working as assistant engineers. Now, pursuant to these orders that were passed in some connected matters, they have been promoted as assistant executive engineers, Division 1 in 2021, my lords. Without even completion of officiating surveys, now they have all been, most of them have been promoted to assistant executive engineer. They have been working there as 10 years. Now, another third batch is being promoted. So, therefore, my lords, they were trying to take time so that the third batch will get promoted. Now, only around another 15-20 vacancies are left out. Their cases are also there. Our file is also there. Our file is held up only because of this order. I have also produced, my lords, that along with a memo.
So who appears for the petitioner?
My lord, DC Deepak, my senior DC Deepak and Advocate Abhinav, my lord.
No, what is it now? How are you aggrieved now?
My lord,
We'll stay the promotion and then we'll hear it.
my
Otherwise,
lord,
they cannot
one
be.
week time, my lord.
So
One
that
week
we'll
time,
see.
please.
But there cannot be any promotion in the meanwhile. That will clarify. Then we'll see. It is the submission of Learned Senior Counsel appearing for the petitioners, respondents, that the present petition has been rendered infructuous as the prayer, the column B, has been satisfied by virtue of. So this has come into force, is it?
Yes, come into force.
Promulgation of Bangalore Mahanagara Palike, General Cadre and Recruitment of Officers and Employees, close bracket, Rules 2018. It is further submitted that the consideration of prayer at C and D would not arise for consideration, and all promotions as of now will have to be in terms of the rules, cadre and recruitment rules referred to above. Full stop. The counsel for the petitioner requests for time. However, Learned Senior Counsel appearing for the respondents, private respondents submit that the limited posts available for promotion would be filled up to their prejudice by virtue of operation of the interim order dated 22/12/2015, whereby the petitioner's case for being promotion is not being considered. Respondent's case for being promoted is not being considered. Accordingly, for the present, the respondent number, BBMP is respondent number. Now you are the one who has to take a decision on promotion. Respondent number.
Finals with the government. Respondent number 1.
Respondent number 1 not to pass any order regarding promotions as regards the
Post of executive engineer.
civil till the next date. List the matter in the, now this is the only point.
This is only point if it's disposed of. Most
So
of the other
now
petitions also.
petitioner, you make your submission as to whether this petition has become infructuous. Otherwise, your promotion also will have to wait. So on the next date, you take instruction and make submission as to whether petition prayer has become infructuous or not. List the matter.
Yes, ma'am.
So that's why. So now let them. So now let them take that stand. Otherwise, they'll have to wait. That's all. So we'll have it on 9th. This is the matter. Now you take your stand. Otherwise, your promotion also will be held up.
My lord.
CNR rules 2018.
Yes.
20. Bottom of the page. Title and comments.
Within bracket, general cadre and recruitment of officers and employee rules 2020. Let us see. We have to finish the earlier matters also. This is the matter. The week commencing from 27th of June. That is June. Let us. No representation for the petitioner. List the matter week after next.
Serial number 19, my lord.
Yes.
Serial number 19,
Yes.
my lord. I'm appearing
Yes.
for the petitioner, my lord. I made an application to of the caste, my lord, because the office objection was raised earlier, my lord. Due to COVID-19, my lord, I'm unable to comply, and subsequently I complied, my lord. Due to that reason, the Honorable Court has directed me to file an application, my lord. I filed, my lord. Kindly we have the caste, my lord, imposed by the Honorable Court, my lord.
What is the cost? How much is the cost?
2,000 rupees, my lord. She is physically challenged, my lord, and she is not working, and she is unable to pay any advocate fees, my lord. Because of that reason, my lord, I request the Honorable Court to waive off the cost, my lord. The Honorable Court has directed me to file a necessary application, my lord. In view of that, my lord, I have filed application, my lord.
In light of the reasons made out in the memorandum of facts filed in support of the application. Cost was imposed as per the order dated.
Order dated, my lord.
Order dated 31/3/2021. The costs imposed as per order dated 31/3/2021 is recalled. Accordingly, is disposed of. Just 1 minute. Just 1 minute. Register General your council High Court of Karnataka. We are standing counsel. Who is the standing counsel for High Court of Karnataka? The counsel Sri M.A. Subramania is directed to accept notice for the first to the respondent. Operation previous matter. Yes, 20.
Since this application has been filed seeking the release of funds that are due to the petitioner as per the interim order of this honorable court. It's been over 2 years and the interim order has not been implemented by the order of right.
There's only an order of stay, isn't it?
There is an order.
No, so what is not being complied with?
Also, the petitioner, as per the order of stay, the petitioner was to be returned to his previous pay grade and scale. It has not happened to date, and he is still working out of Calcutta when he should be working out of Bangalore.
Let us see now. There is an order of stay. Now they'll have to comply with it unless they seek for modification.
I request a date to be fixed.
This is the matter.
But the order was given effect and subsequently after 6 months, 7 months later, they have filed a petition and the one order was before the interim order was the order was the order punishing the petitioner was saved by this honorable court thereafter.
The statement of objections to be filed within 3 weeks, failing which costs would be imposed. Yes, list the matter immediately thereafter. Yes.
The case of the petitioner is he was promoted to officer's cadre and he was given fitment, provisional fitment on promotion. Thereafter, the fitment formula was issued by the Indian Banks Association, which is not implemented by the respondent bank. So, a direction is sought from this honorable court, writ of mandamus, to implement the fitment formula issued by Indian Banks Association.
Yes.
First of all, there is a delay. He retired in 2011, voluntary retirement. After 9 years, he files his petition, claiming there certain anomaly was there, taking his fitment. Now he claims as on the basis of the annexure E, which is the Indian Bank circular, that his fitment has to be revised. He subsequently gives an representation annexure G based on that circular to fix his fitment. But what my submission according to the Indian Bank circular is not applicable because we have our own circular of fitment formula.
Then you file your statement. You filed. And then we'll have it for final hearing.
The date may fix for hearing.
We'll hear the matter, not at this stage, not in the IA stage. List the matter for final hearing in the first week of July. Accordingly, IA is disposed of. Yes. It's not limited there. The interim order is not limited. Not the next day to the serial number 20. Serial number 20, interim order earlier grant is extended till the next day. The who should be made a party? You see, if the complainant is going to be affected, then you'll have to make a party. Learned counsel for the petitioner undertakes to implead the complainant as an additional respondent. What is this IA for disposal? Who's the
Went abroad after where? No, she has not gone abroad. She went abroad.
No, what is correct? What is the interim order passed?
Order, my lord, this stay of the inquiry, my lord. So, issuing a show cause notice, my lord, they direct issue the charge sheet. Which called in question, my lord, I said, first issue a show cause notice.
No, correct. Now, you should report for duty. That has nothing to do with your inquiry.
I was appointed with duty, my lord.
No, forget that. What is the interim order? Interim order is further proceedings pursuant to the charge sheet is stayed. And then
I asked for a transfer.
that's a different matter. That's how we can consider here.
There is one more intervention, my lord.
That you see, if there's a stay, that's a different matter. Not otherwise. You will have to report for duty.
I have a medical condition, my lord.
Where is the order of stay? Suppose there's an order of stay, it's a different matter. But you can't sit at home now.
I'm not sitting at home, my lord. I attended the duties, my lord.
Where are you?
My lord, that my health condition, because they posted me, my lord, somewhere more than 300 kilometers, my lord, around 11 hours training. I was appointed in duty. They posted me somewhere in Chitradurga, my lord. I said my health condition has not permitted me to go there. Please transport me somewhere near to Chitradurga. Then I produced my doctor's certificate, my lord, and saying that I'm unable to come.
Last 1 years, is not
Then correct. Now nothing prevents you from initiating disciplinary proceedings for that. In interim orders only insofar as departmental proceedings. Where is it stated that she can sit at home? Start. Who's preventing you? Now, the departmental inquiry proceeding is stayed, isn't it? Now, despite that, she is in employment, so she is to work. Now, if she is not coming to work, nothing holds your hands to initiate proceedings for that. So that correct. That is open to you. We are not holding your hands. We are not preventing you from initiating proceedings for unauthorized absence. That it's up to you. So we leave it to you. So this interim order has nothing to do with your presence in your office. So correct. Now we are saying, why do you say that the stay of the departmental proceeding results in her not coming to work? They only state the departmental proceedings. She has to come to work. And then you initiate proceeding, fresh proceeding. That has nothing to do with the present proceeding. We have not stated that she is not to work. Now you will have to approach them and sort it out. You can't sit at home. That is wrong. No, but when is that? From past 2 years, if you are not working, then you can't have a vested right for that. That's a different matter, not in these proceedings. No, but that is something between you and the employer. We cannot force the employer to give you a posting. That you move that matter. The respondent submits that petitioner has not reported for duty. Suffice it to say, we have not the petitioner's non-reporting for duty is a matter with respect to which respondent is at liberty to take appropriate action.
She has not completed 3 years of minimum years
This matter. That will see that you move that matter, or you initiate disciplinary proceedings, then they'll only move the matter. Yes. Which one? In which matter? No, this one, let the pleadings are complete. This is the matter in the recommencing from 27th of June. No, but you will have to sort out your reporting. You can't sit at home for so long. Yes, next. Yes.
Some date may continue.
What is the urgency of this matter?
Question of law involved in this matter is very short. The urgency is that though the petitioners are receiving pensionary benefits, a large chunk of the benefits that they are to receive has been excluded by them, despite being covered by a judgment of disorder. They have excluded a portion of the amount of pension that they are to receive. In the morning, they called me and they wanted some time. Before I'm requesting.
At request of the respondent, list the matter on 22nd. By that date, you complete your instruction.
The IMA then, they have filed an IA for posting.
One of 22 is disposed of as coming fine. No further orders. The transfer matter. Why does it say promotion? No, you do it. They want a posting. That's all. She wants a posting. No, is there any stay order? No, now what is to be done? So far as you appeared for the fourth response. So you want a posting
Yes.
and at any place, not necessarily at the place of the petitioner. No, then the fourth respondent is saying that if there's any available vacancy in Hassan, so we'll record that in dispositor. So there is so how many more years you have? Now what is
One notification is on my behalf and the other notification is on our behalf.
you just tell me the fact? I've forgotten the fact. I've forgotten the fact. Just tell me.
These are reported for the 20 minutes. The present case of work on 11/3/2019.
On as per annexure. Page
14. Correct. Black and Rajesh. Black and Rajesh. This is the date of the Teller or no bigger. Reported for the duty in the present place on 11/3/2019.
Yes. As a what post?
As a prestigious assistant.
Yes.
It is a vacant post started by the retirement of one person.
So what is the tenure?
It is the 4 years as
Group C post. 4 years.
4 years minutes. It is at page number 24 minutes.
So up till 23 March, you have protection. Yes.
So page number 24 is the tenure.
Yes.
As per transfer candidates. No minutes as per C&D minutes.
Yes.
Transfer to my place.
Transfer to your place. Yes.
I have not been completed. Not completed without tenure, and also the such orders have not been approved by the honorable.
So now the fourth respondent is ready to accept any posting in the district of Hassan. Recording that will. So in effect, there is no chief minister's approval for premature transfer. That's except the petitioner had reported for duty as first division assistant, Town Municipal Council, Chandrayapatna, on 11/3/2019. It is submitted that as regards the petitioner's post, which is at annexure 4 years. It is submitted that as regards the petitioner's post of Group C post, the normal period tenure at any particular place would be 4 years. It is further submitted that as per the impugned order at annexure C and D, the fourth respondent was posted to the place of the petitioner, which posting has been challenged. The petitioner submits that the posting of the fourth respondent is in violation of guidelines regarding transfer of government servants. Next, it is further submitted that the order of transfer being premature, the deviation is permissible only with the approval of the chief minister, which has not been obtained in the present case. Such assertion has not been denied by the contesting respondent state. Next, the fourth respondent submits that she is ready to accept any posting in the district of Hassan. Where government advocate upon instruction submits necessary posting would be given to the fourth respondent within a period not later than 3 weeks. In light of the above and the undertaking by the state as regards granting posting to the fourth respondent, the petition is disposed of. No grounds are made to interfere with the impugned orders. The impugned orders for the transfer at actually C and D are set aside. C and D are set aside in light of the same being in interference with the tenure and as the transfers being premature do not have the previous approval of the Chief Minister. Accordingly, petition is disposed of. Insofar as the posting of the fourth respondent is at liberty to make appropriate representation regarding her posting. Same to be made within a period of 1 week from date from this date. So that your order we have upheld.
It's actually a failed petition because the HSC Act is involved and we converted it to criminal appeal method.
Yes. Yes, who appears for the state pass over. Who's for the petitioner?
This matter, junior country, certainly,
So we'll have it at request list the matter after 2 weeks. Date kodada review petition. 2 weeks any Friday. 17th. Yes. We'll list the matter next week.
Lord, I appeal for the petitioner. Serial number 20. Serial number 28, I appear for the review petitioners.
She's there. Alidare, chagidare. Respond. Let us see. No, let him come now. He was appearing regularly before, and now he has become irregular.
Oh, all right, Manoj. Please.
Relist the matter. We'll have it next Friday. You please intimate him.
Please,
Intimate him.
Please.
10 to 11 next day. 17th. Yes. No representation on behalf of the petitioner. Relist the matter week after next. Has this become infructuous? 32. What is 32? Stay there. Mostly infructuous ಆಗಿರ್ಬೇಕು ನೋಡಿ. Huh? We'll have it on Wednesday. List the matter in orders list. Government advocate to verify as to whether the relief sought for does not survive for consideration. The aided institution, is it? So you are the competent authority. Let's just find out. Yes.
Right, not a bit of random. The respondent substantial copies.
To furnish?
Right. Saying this honorable court is a bit of random direction. The respondents to issue subsequent copies of the statement of witnesses, complaint and inquiry report because the petitioner has been deported from the post office, treasurer to the post office, build a secretary by. Because of that reason, he could not able to initiate any legal action against the respondents for want of certificate copies. Honorable Lordship has issue notices.
Notice to the respondents. But these are private entities. How a writ will.
Now, the act is not applicable.
No, correct. What I'm saying is.
It's a company, private limited company.
How will a writ of how can a writ of mandamus be issued to them? Must be a state entity, isn't it? If then how we can issue a writ? If unless the respondents are state, how we can issue a writ of mandamus? Now I'll have it next week. Correct, counsel. Please examine that point and make submission. I'll have it next week. Only on the short ground that the respondents not being state, how do we issue a writ? Is there any other remedy? Find out and make a submission of the petitioner to state as to how writ of mandamus is maintainable as against the respondents which are private and prima facie non-state entities. This is the matter. Date 15. Now the question or their defense is on the ground that where there may be any fault on the part of the power company, no doubt we can hold a strict liability, etc. But where they have no role, and this is at the instance of some other party. That's all. That's what they are trying to say, and they relied on some judgments. So, how are you going to distinguish these judgments? One, yes. So there are two categories. One wherein you can attribute some role to the respondents, and the other where they say suppose somebody wants to hang some clothes over a height electric wire and they hang their clothes electric wire. According to them, no, this category will have to be treated differently.
So that's great of Melon.
Yes.
Division bench in Bhagyabai's case, it was a case where the owner had illegally fenced electrified their fence. The deceased was the farmer who went in search of his cow and he didn't know and he got electrocuted and he died. The petition was filed before this honorable court. When a single judge may not dismissed it, saying that you will have to go to the civil court. The division bench may not. Please, my lord. And even in HSEB's case, it's the same defense that for some other reason the electric wire has fallen down, so it's not our fault. That defense has been rejected by the honorable Supreme.
Even Bhagyabhai's case was not carried in appeal before on the Honorable Supreme Court by Westcom, and they finally the order was upheld, and they paid the compensation with liberty to Westcom to recover the money from the owner if they feel that they are negligent.
Let us look at the observation. Yes. Yes.
More citation. The decisions that they relied upon, my lord, are there.
So we are also on the broader principle wherein they are trying to make a distinction of one category of cases, saying that these category of cases wherein which they don't have any role, and solely at the instance of some intervener, we are the logic of the earlier judgments cannot be explained.
That difference really doesn't stand. So all the matters that they relied upon. The fundamental difference is this, my lord. One set of cases are before the 2010 regulations came into force. The 2010 regulations, my lord, make it mandatory. The maintenance is on, the onus is on the companies, whether it's the production or the distribution companies. I taken my lord to the various provisions of the regulation, the 2010 regulation. Ask this on, my lord, this is just legal submission to assist this honorable court on each of these points.
No, what we are saying that irrespective of whatever obligation may have been imposed under the new regulation, if you go on the larger principle of, you say, strict liability, sans the defenses, then this question of before after doesn't arise on first principles. For that, the only thing you'll have to make out is that this is a case, as they said in that Shail Kumari's case, that it's a case of strict liability without defense.
That's the law, my lord. The law as it stands. Shail Kumari has not been overruled. Shail Kumari holds the field. There are umpteen number of judgments, my lord, where Shail Kumari has been relied upon. In fact, the decisions that they have relied upon, Shail Kumari is not even brought to the attention of the honorable court. This line of judgments, my lord. I will just take those one by one, my lord.
Yes. Yes.
The decisions, then I will.
Yes.
The first decision, my lord, is Madan and others versus NDPL and others. The Delhi High Court judgment that they relied upon. My lord will please state that para 4 of that decision.
Para 4 of?
That judgment, Madan and others, which the respondents have relied upon.
They have given a compilation, is it, or just handed over? Or just compilation.
Madan and others versus NDPL and others. Delhi High Court.
Yes.
Para 4 of the first decision. Para 4 of the first of that decision, my lord. The ownership of the offending buyers is in dispute, my lord. The argument, in fact, my lord, the defense is that this is not an electrified area at all. Who is the owner of the wire was the dispute, my lord.
Who is the owner of?
Who is the owner of the wire? That was the dispute that was raised. The wire which was the cause of the electrocution, the ownership of that wire itself was in dispute. as to whether it was the ownership of the state at all. My lord, may please see the last paragraph, the last column of this table.
Referring to the table.
The table that I just. Distinguishable, my lord, are not applicable to current case.
Yes.
First is the ownership was in dispute. Secondly, my lord, the report of the electrical inspector under section 161, that was not even produced. There is no record to even indicate whether that particular procedure was carried out. Thirdly, there are no reference to the 2010 regulations. And lastly, my lord, that doctrine of absolute liability was not even brought to the attention of the Honorable Court. There is no discussion of MC Mehta. There is no discussion on Shail Kumari.
Yes.
In that instance, my lord, that judgment will not be of assistance to the respondents, is my humble submission. The second, my lord, is our Karnataka High Court, Ashwini Manoj Patil and others. My lord, may please see para 18 of that judgment. That's, my lord, a very unfortunate case where a person went and held on to the cage that was covering some electric area, and the person got electrocuted. Para 18, the dispute is whether he died because of electrocution at all. Para 18 of that decision. The decision is Ashwini Manoj Patil, others. 2016, volume 5, Karnataka LJ, page 511.
So they've given the order of the writ petition itself. That.
Please.
Ashwini Manoj.
Yes, sir.
Which paragraph?
Paragraph 18, please. The question is whether he died because of electrocution or cardiac arrest. That was the dispute.
The para number differs. Let us. Yes.
Please see at the bottom of that page, at the bottom of that paragraph, the first paragraph at the top.
Yes.
Whether the death was by electrocution or cardiac failure, that was the dispute, my lord. The question of maintainability was raised, my lord, and relegated to the civil court. In these batch of matters, my lord, the report of the electrical inspector, yet again, my lord, the electrical inspector report under 161 is a statutory report. It's an independent, it's an electric, it's an independent body.
In none of these cases, there's any report of the electrical.
No, my lord. Only in Ashwini Patil, the report is referred to. In fact, the defense taken in Ashwini Patil is that the report has been produced and the report is by an independent person. And hence they got the petition dismissed, my lord.
So the genuineness of it itself was in question.
Yes, my lord. The genuineness, whether the death was electrocution or not. The other, my lord, is Malappa, my lord, directly relies only on Ashwini Manoj Patil.
So in Ashwini Manoj Patil, there is also some cloud over the genuineness of the report.
Please, no, my lord, the report there is no, there is a question about the genuineness. But the main point there was, my lord, that the death could have been for other reasons, not electrocution. That was the dispute. And my lord, may please see, even in Malappa, the learned single judge, my lord, actually takes judicial notice of an order of this honorable court, where a similar case was entertained and compensation was granted. And for some reason, my lord, doesn't rely upon that. If I could just point out, my lord, it's a para 8 as per what I said.
Other matters are not likely to reach this. The further hearing matter will take till lunchtime. So after lunch, after the division bench matter, so we can see the remaining part of the list. Yes.
Para 8 of this decision, my lord, and Malappa's decision.
Para 8.
The reliance is based on Sri Manjula. Judicial notice is taken of the judgment with Srimati Manjula and others versus Discom. Paragraph.
Malappa's case.
Manjula and others, my lord.
No, para
8.
Yes.
Please, my lord, may please know. This is a case which was, which the Honorable High Court, my lord, allowed, and compensation was granted. But the subsequent paragraph of the learned single judge, my lord, says that the respondent, that the petitioners were not able to show whether this has been upheld and whether it has been relied upon in any subsequent judgment.
Read the observation. Read the observation.
The decisions were given to us.
Yes. No, this is that special order matter. Correct. So what we'll do, this will have to be prioritized, justifiably so. So on the next date, I'll ensure the Fridays are being kept apart only for the special order matters and for division bench in the afternoon. So actually in the intervening, they have put some other matters and service matters which took some time. So I will ensure that after this further hearing, this will come consecutively. As soon as that gets over, I will take this up. So it will be in the list and I'll ensure that it comes up higher. So as soon as the further hearing matter, so you just find out at what stage. Immediately after that, this will be taken. I made a note of it, but you follow it up like that. So as soon, no, this must complete. That further hearing matter must complete. So that may take another 1 or 2 hearing dates. So you just keep in touch with them. On the day there's going to conclude. Yes, it will be on the board. So and the understanding that after I dispose of this 34.2, your matter will.
Para 8, my lord, of Malappa.
Yes.
In the order passed by one of the learned single judge of this court, in Srimati Manjula and others versus Discom, the learned single judge even held in a case of theft of electricity by the deceased and family members that it is the duty of the respondent Discom to take action against such illegal theft of electricity and applying the principle of strict liability. The learned single judge, adopting the principles of awarding compensation in cases of motor vehicle accounts, granted the compensation in the cases of electrocution. The relevant paras 5 to 7 of the said order are quoted below for ready reference. It is commonplace that whenever public celebrations are done, the persons who organize such public celebrations would freely, without any inhibition, draw power from supply lines. The electricity authorities keep themselves deliberately blinded and do not take any action against such illegal theft of electricity. The electricity company in this case has not taken any proper preventive action to prevent theft of electricity to be used freely without any proper precaution to prevent risk of public danger. In that view of the matter, The respondents 1 and 2 would be very much liable under the principle of strict liability enunciated in Paramjit Kaur and others versus State of Punjab and others, reported in 2010 ACJ 9, page number 5957. The plea is that the respondents are also liable for negligent maintenance in supply of power. The contention that there was proper diligence and care taken on the part of the respondent number 1 and 2 is not tenable, and they cannot avoid liability in case of strict liability. In that view of the matter, the respondents 1 and 2 cannot waive liability to pay the compensation. The contention that the case involves investigation into complicated questions of fact, the writ petitions are not maintainable, is untenable. The documentary evidence produced expressly discloses that Nagraj died on account of electrocution and that the respondents 1 and 2 would be very much liable to pay the compensation on the principle of strict liability. With regard to quantum of compensation, the law is well set. In the cases of motor vehicle accidents, the multiplier system is adopted. The said method is a foolproof system for assessing the damages. In that view of the matter, the multiplier system is adopted. It does not offer any difficulty for the court to assess the compensation in the present case. The next is the calculations. My lord, may please see para 9, how the learned single judge, my lord, deals with this judgment. The learned counsel for the respondent companies were unable to point out whether any intra-court appeal was preferred against the said order passed by the learned single judge or not, and whether the said judgments hold the field even now. On the other hand, learned counsel for the petitioners submits that even the compensation awarded in that case stood paid to the petitioners, which is not rebutted, my lord. So, my lord, the learned single judge having this judgment having been brought to the attention of the learned single judge, but and there is no reasoning, my lord, as to why it is being distinguished. In fact, it is not being distinguished. So, with great respect, my lord, this order of the learned single judge, my lord, is per inferium. It's my humble submission.
It will be only treated to be on the facts of the case.
But it's a slew of petitions which were dismissed. And in fact, in this, my lord, the learned single judge actually goes to the Fatal Accidents Act of 1955. That's the reasoning that is given. That, my lord, is law of torts, my lord. That's a private law remedy. What the petitioners are before this honorable court, my lord, it's a public law remedy. For violation of your fundamental rights, your human rights, the state is liable to pay compensation. It's an entirely different remedy. In fact, it is in addition to our private law remedy. That's what the Honorable Supreme Court has laid on from Neelabati Behra onwards. Slew of judgments on that line. So this decision, my lord, of this Honorable Court is distinguished, my lord, on this grounds. And my humble submission, my lord, with great respect to the learned judge, my lord, is rendered per inferium is my submission, my lord. Yet again, my lord, no reference to the 2003 Act, no reference to the 2010 regulations in this order as well, my lord. And the division bench order in Bhagya Bai's case, that has not been brought to the attention of the learned judge, my lord.
Yes.
The next decision which my learned friend relied upon, my lord, is Sri Hanumantappa versus Chief Engineer Bescom. Respondents, my lord, they disputed the negligence on their part at para 4. Hanumantappa versus Chief Engineer Bescom.
Yes.
At para 4 of this.
Single judge can only say, we can't say per inferium, we must only say there is another Supreme Court judgment by which I am bound. Yes.
This, my lord, yet again, the report of the electrical inspector is not brought to the attention of the court.
Yes.
And now, my lord, it's that line. So this judgment relies upon Mallappa. Mallappa relies upon Ashwini Patil.
Yes.
The next decision which they relied upon, my lord, is Ranganath versus Bescom, 2020 SEC. Again, it's another line of cases, my lord. Incidentally, my lord, may please see para 3C. Compensation was granted in this matter because previously compensation had been enhanced.
Compensation is granted.
Yes, my lord, at para 3C. 7, my lord.
Yes.
The contention of the learned panel counsel for the respondent, electricity supply companies, that all these deaths happened long ago, and that the kins of the deceased have been granted a sum of 1 lakh rupees by way of ex gratia soon after the death, and thereafter these petitions have been filed after inordinate delay and laches should be dismissed, does not impress the court. Death of a citizen cannot go uncompensated, and the same is actionable in law. The framers of the Constitution, in their wisdom, deliberately did not prescribe any period of limitation for seeking remedies for violation of the fundamental rights. Ordinarily, such remedies should be resorted to without proving delay and laches. However, the legitimate relief which the petitioners are otherwise entitled to at the hands of the writ court cannot be denied on the mere ground of delay and laches, since it does not behoove the state or its instrumentalities to defeat a legitimate claim of poor citizens on such technical grounds as held by so and so. The Lord may please see. In all the 3 cases mentioned above, the learned coordinated judges of this court have awarded an additional compensation of ₹1 lakh person to the circular dated so and so to the kins of the deceased, even when there was a long delay. There is no reason or rhyme for denying similar relief to these 4 petitioners as well. So, over and above what the circular granted, additional compensation has been granted. My submission is having arrived at the conclusion that, as the learned judge says, my lord, it cannot go uncompensated. Then the principles laid down for granting of compensation should have been looked at, my lord, and compensation should have been given in those terms. The honorable judge, my lord, of course, relying because there was a previous judgment, has relied and said, okay, 1 lakh compensation extra for all of this.
This is more on the quantification they relied on. Yes.
The next decision, my lord, is SDO Grid Corporation and of Orissa Limited and others versus Tiruvaram. 2005, Volume 6, FCC, page 156. That, my lord, in fact, was considered by the division bench in Bhagya Bai's case.
This SDO Grid.
Yes, my lord. Tiruvaram was considered specifically the same contention. The division bench, my lord, considered it and rejected that argument.
Yes.
The next decision, my lord, that they are relying upon is Sukamani Das, again from Chairman Rilko. In that decision, my lord, my humble submission is this. The judgments on strict liability were not brought to the attention of the court. And this decision is in 1999, my lord. The law has traversed much after that. In HSEB case, before the Honorable Supreme Court, this judgment, the attention was drawn to this judgment. This Honorable Court took notice of it and granted compensation. This is the second judgment in my compilation.
Yes.
Now, the next decision that was relied upon is Tamil Nadu Electricity Board versus Sunnati and others, 2004 SCC 543. In that, my lord, in fact, of course, again, the dismissal is there. But my lord, may please see the observations at para 10. Not in all matters, my lord, whether there are disputed questions, does the petitioner have to be delegated. Now, what is before your honorable, dishonorable court, my lord? In all the cases, there are reports under section 161. In all cases, the death by electrocution, case, or the injury to the petitioners I am representing, that is undisputed. It is because of electrocution. So the negligence question, my lord, goes out of the window because of the judgments of the Honorable Supreme Court, my lord. And this line of judgments does not help my learned friends, my lord. Yet again, my lord, this Tamil Nadu board was prior to the 2003 Act prior to the 2010 regulations. These are all the decisions, my lord, that were relied upon by my learned friend, my lord. My humble submission is that they are definitely not applicable to this matter.
So just show me the observation MC Mehta and Shail Kumari once again. Bhagya Bhai. Yes.
MC Mehta, my lord, is at page 121.
Just 1 minute. So far as the treating of electricity as a hazardous substance. So just have a look at this. I have not gone through fully. AIR 1998, Allahabad, page 1. I have not completely gone through, but there is some prima facie observation that electricity by itself is a hazardous substance. Now you take me to your judgments.
Shail Kumari, that is the Honorable Supreme Court also.
So let us just have a look at it.
The first judgment.
Yes.
Paras 7 on the
This is Shail Kumari.
Shail Kumari. Running page 3. Please read from Paras 7.
Para 7. This is of 2 judges.
Please.
Yes.
It is an admitted fact that the responsibility to supply electric energy in the particular locality was statutorily conferred on the board. If the energy so transmitted causes injury or death of a human being who gets unknowingly trapped into it, the primary liability to compensate the sufferer is that of the supplier of electric energy. So far as the voltage of electricity transmitted through the wires is potentially of dangerous dimension, the managers of its supply have the added duty to take all safety measures to prevent escape of such energy, or to see that the wire snap would not remain live on the road, as users of such road would be put under peril. It is no defense on the part of the management of the board that somebody committed mischief by siphoning such energy to his private property, and that the electrocution was from such diverted line. It is the lookout of the managers of the supply system to prevent such pilferage by installing necessary devices. At any rate, if any live wire gets snapped and fell on the public road, the electric current thereon should automatically have been disrupted. Authorities manning such dangerous commodities have extra duty to chalk out measures to prevent such mishaps. Even assuming that all such measures have been adopted, a person undertaking an activity involving hazardous or risky exposure to human life is liable under law of torts to compensate for the injuries suffered by any other person, irrespective of any negligence or carelessness on the part of the managers of such undertakings. The basis of such liability is that foreseeable risk inherent in the very nature of such activity. The liability cast on such person is known in law as strict liability. It differs from the liability which arises on account of the negligence or fault in this way. That is, the concept of negligence comprehends that the foreseeable harm should be avoided by taking necessary reasonable precautions. If the defendant did all that which could be done for avoiding the harm, he cannot be held liable when the action is based on any negligence attributed. But such consideration is not relevant in cases of strict liability, where the defendant is held liable irrespective of whether he could have avoided the particular harm by taking precautions. The doctrine of strict liability has its origin in English common law when it was propounded in the celebrated case of Rylance versus Fletcher. Blackburn Judge, the author of the said rule, had observed thus in the said decision. The true rule of law is that the person who, for his own purposes, brings on his land and collects and keeps there anything likely to do mischief, if it escapes, must keep it at his peril. And if he does not do so, he is prima facie answerable for all the damage which is the natural consequence of the escape. There are seven exceptions formulated by means of case law to the doctrine of strict liability. It is unnecessary to enumerate those exceptions, barring one, which is this act of stranger. That is, if the escape was caused by the unforeseeable act of a stranger, the rule does not apply. The rule of strict liability has been approved and followed in many subsequent cases in England. A recent decision in recognition of the said doctrine is rendered by the House of Lords in Cambridge Water Company Limited versus Eastern Counties Leather. The said principle gained approval in India, and decisions of the High Courts are legion to that effect. A constitution bench of this court in Charulal Sahu versus Union of India, that's the Bhopal gas case, and a division bench in Gujarat SRTC versus Ramanbhai Prabhabai had followed with approval the principle of line and temperature by referring to the above two decisions. The two-bench bench of this court has reiterated the same principle in Kaushanama Begum versus New India Assurance Company Limited. In MC Mehta versus Union of India, this court has gone even beyond the rule of strict liability by holding that when an enterprise is engaged in a hazardous or inherently dangerous activity and harm is caused on anyone on account of the accident in the operation of such activity, the enterprise is strictly and absolutely liable to compensate those who are affected by the accident. Such liability is not subject to any of the exceptions to the principle of strict liability under the rule of Rylance and Fletcher. In the present case, the board made an endeavor to rely on the exception to the rule of strict liability, Rylance and Fletcher, being an act of stranger. The said exception is not available to the board as the act attributed to the third respondent should reasonably have been anticipated, or at any rate, its consequences should have been prevented by the appellate board. In Northwestern Utilities Limited versus London Guarantee Accident Company Limited, the Privy Council repelled the contention of the defendant based on the aforesaid citation. In that case, skip from here, Miller. Para 15, may please listen. I did para 15, Miller.
Yes. So just read off that.
I'll read it, Miller. In that case, a hotel belonging to the plaintiff was destroyed in a fire caused by the escape and ignition of natural gas. The gas had percolated into the hotel basement from a fractured welded joint in an intermediate pressure main situated below the street level and belonging to the defendants, which was a public company. The fracture was caused during the construction involving underground work by a third party. The Privy Council held that the risk involved in the operation undertaken by the defendant was so great that a high degree care was expected of him, since the defendant ought to have appreciated the possibility of such leakage. The Privy Council has observed in Quebec Heat and Power Company Limited versus Amri, that the company supplying electricity is liable for the damage without proof that they have been negligent. Even the defense that the cables were disrupted on account of a violent wind and high tension current found its way through the low tension cable into the premises of the respondents was held to be not a justifiable defense. Thus, merely because the illegal act could be attributed to a stranger is not enough to absolve the liability of the board regarding the live wire running the road. In West Bengal SCB versus Sachin Banerjee, the electricity board adopted a defense that the electric lines were illegally hooked for pilferage purpose. This court said that the board cannot be held to be liable, negligent on the said fact situation, but the question of strict liability was not taken up in that case.
To distinguish the judgment in that West Bengal one.
Please, my lord. And on this ground, my lord, that strict liability was not considered. In the entire line of judgments, my lord, which my learned friend has relied upon, strict liability has not been considered. Shahid Kumari, MC Mehta, Bhagya Bai, none of these judgments have been brought to the attention of the learned judge.
On the larger principle, if we are to take Shahid Kumari and then say electricity being inherently dangerous, its escape in the sense of being conducted by the aluminium ladder, which could be construed to be an escape, will fall within is something that was foreseeable by by both of them, not only by his client, by her client also. Because what is it? It is the electricity. I'm just saying, I'm thinking, I've not made up my mind. So if you look at the electricity as being an inherently dangerous object, or and that if it's being supplied by both of them together, its escape in terms of literally by saying if it is if you use an aluminium ladder and its conduct, that could be construed to be an escape, for which is a reasonably foreseeable consequence of that very act of electric supply. And then so on that broad principle of torts and its extension of MC Mehta, according to you, and Shail Kumari, that would be the broad principle in which we have to look at.
That's my point. And especially because, my lord, the 2010 regulations.
So according to me, there are two aspects of it. One is on this principle of strict liability, sans the defenses of strict liability. The second would be liability arising from the 2010 regulations, and then hold that the non-maintenance of earthing equipment resulting in no cutoff in the power supply would be something for which the KPTCL here would be held liable, because their equipment to cut off power did not work under the 2010.
This 7-year-old boy suffers electrocution from a 66 kV wire. The department is aware that that wire is there. They issue show cause notices to the owner. He's a tenant. He's the son of a tenant living in that. They issue show cause notices. In reply to the second show cause notice, an undertaking is taken from the owner of the house that in the event of there being any unforeseen, unfortunate incident, you will be liable.
It is for their satisfaction.
But it is highly inappropriate, it's illegal, and it's putting at risk, my lord. And now we have a 7-year-old child whose entire life has been, in fact, my lord, 40 lakhs or 50 lakhs is the compensation that the Child Rights Commission ordered in regard to that child. The child has to go through at least 7 stages of surgery, my lord, to look presentable now.
So we can look at it one on the basic principles of strict liability without defenses in Shail Kumaris. And the second limb would be the non-implementation of Regulation 2010. Now, after Shail Kumari, which is the next one?
My lord, HSCB, that's at page 7.
No, but that has been distinguished in this judgment. No, that is HS
HSCB, page 7, running page 7.
Yes.
My learned friend, my lord, had relied upon, my lord may please see para 2 at page 8.
Just 1 minute. Yes.
Second citation, my lord, is volume 2004, volume 5, SCC 793, HSCB and others versus Ramnath and others. In my legal submissions, it's there, my lord. But I will just take my lords for some of these paras.
Yes.
Para 2 may please be seen.
Yes.
Over the page. Reliance is placed upon the case of Chairman Grid Corporation of Orissa Limited Grid Co versus Sukhmani Das, wherein a person walking along the road came in contact with a live wire which was lying on the road after having got snapped from the overhead electric line. The writ petition was filed claiming compensation. The High Court directed payment of compensation. However, this court held that the disputed questions of fact arose and that a writ petition was not the proper remedy. On the basis of this authority, it is urged that even in this case, disputed questions of fact arose, and therefore the High Court should not have entertained the writ petition. Please see para 4. Here, my lord, is an unauthorized colony. I will read para 3, my lord, to understand. In order to consider this submission, one has to look at the averments made in the petition and the reply to those averments. In para 2 of the petition, it is stated as follows: that the petitioners are residing in their house in Shaktinagar colony near Kagri railway crossing for over 15 years, and a high tension line is passing over the house of the petitioners at a much lower height than prescribed under the rules. The said line has become quite loose and drooping and touching the roof of the house of the petitioners for the last 2 years. The petitioners, as well as other inhabitants of the aforesaid colony, have been requesting respondents to tighten the said HT line for the last about 2 years, repeatedly in writing and verbally, by calling on them in their respective offices, but they did not bother for the same. In the written statement, there is no denial to these averments. All that is claimed is that the entire colony was an unauthorized colony, and the unauthorizedly, the height of the houses had been raised. It is claimed that the wires were at a prescribed height of 20 feet from the ground level, and that the height of the wire was as per the standard prescribed under the rules. It is submitted that these averments would show that there was a disputed question of fact as to whether or not the wires were touching the roof. We are unable to accept this submission. To the categoric averments set out here and above, that the wires had become loose and were drooping and touching the roof of the houses, there is no denial. To the categoric averments that the complainants have been made, both in writing and orally, requesting that the wires had to be tightened, there is no denial. A mere vague statement to the effect that the height was as per the prescribed limit does not detract from the fact that there is a deemed admission that the wires were drooping and touching the roofs. The appellants are carrying on business which is inherently dangerous. If a person were to come into contact with a high tension wire, he is bound to receive serious injury and or die. As they are carrying on a business which is inherently dangerous, the appellants would have to ensure that no injury results from their activities. If they find that unauthorized constructions have been put up close to their wires, it is their duty to ensure that the construction is got demolished by moving the appropriate authorities and, if necessary, by moving a court of law. Otherwise, they would take the consequences of their inaction. If there are complaints that these wires are drooping and are almost touching houses, they have to ensure that the required distance is kept between the houses and the wires, even though the houses be unauthorized. In this case, we do not find any disputed question of fact. As the child has come in contact with the live wire and has succumbed to a industries, in our view, the compensation of rupees 1 lakh awarded by the High Court cannot be unreasonable.
Any foreseeable consequence of an action, even at the instance of any third party, being by itself a foreseeable action, linked to the inherently dangerous activity being carried on by them, is a consequence they are to follow. Yes.
The next decision is Division Bench of our Honorable High Court. This is Bhagya Bai's case.
On a lighter vein, the judges are absolute liability for the lawyers, irrespective of defense, that there was some fight in the judge's house. Lawyers will have to face the judge and consequences will follow. Yes.
My lord, in fact, this matter we argued 10 years back. This is Bhagya Bai's case.
Yes.
Before the single bench, before the division bench.
Yes.
My lord, my please. Para 7. Para 6, my lord, at page 15.
Para
6 at page 15. Page 6, running page 15. The report, my lord, the 161 report that we keep referring to, that is brought on record here, my lord.
Yes.
Next page, my lord, para 7. I could just read the 6 lines from the previous para. Further, the documents at annexure so and so, wherein the Westcom has sought to reply to the appellants with regard to the claim relating to compensation, would indicate that the nature and fact of the accident by which the death has occurred has not been disputed. But the contention has been that the landowner and the watchman are liable to pay compensation, not Westcom. This is the case, where there was theft of electricity. In the above circumstances, it would be appropriate to refer to the decision in the case of Madhya Pradesh Electricity Board versus Shahid Kumari and others, relied on the related counsel for the appellant. In the said case, though the trial court had come to the conclusion that the claimants are entitled to a compensation of so and so as against a claim, had dismissed the suit only on the ground that the claimants failed to prove who was liable to pay the determined compensation. When the parties were before the High Court of Madhya Pradesh, the division bench allowed the appeal and directed the Electricity Board to pay the compensation which had been determined. In that circumstance, when the Electricity Board had called in question the judgment of the division bench of the Honorable Supreme Court, the appeal was dismissed. In the said decision, this Honorable Supreme Court observed as follows: what I just read out, para 7 and 8 in Shahid Kumari. Page 18, my lord.
Yes.
The said conclusion had been reached by the Honorable Supreme Court after noticing the contention on behalf of the Electricity Board that the death had occurred in a circumstance when one Hari Gaikwad had taken a wire from a main supply line in order to siphon the energy for his own use, and the said act of pilferage was done clandestinely without the notice of the board. The said contention was however not accepted by the Honorable Supreme Court. In that circumstance, though the learned counsel for the respondent Westcom has relied on the decision of the Honorable Supreme Court in the case of SDO Grid Corporation of Odisha Limited and others versus Timudo Oram, the same would not assist the contention of the respondent. I would like to read the next paragraph. The facts in the said case cannot be said to be analogous, since firstly, the petition under 226 of the Constitution of India was filed immediately after a civil suit had been dismissed on the same cause of action. Secondly, the decision in the case of Shahid Kumari, cited by the learned counsel for the appellants herein, though noticed by the Honorable Supreme Court, has not been commented upon or disapproved in the said decision, though subsequent, but has only been distinguished as not applicable to the facts which were being examined by the Honorable Supreme Court. In that background, since we have already noticed that a similar defense as put forth in the case on hand has been rejected by the Honorable Supreme Court in the case of Shahid Kumari, wherein it was held that the dependents of the deceased were entitled to compensation. In the instant case also, the appropriate compensation is to be determined and granted. This, my lord, was carried in appeal. Page 24, my lord, is the order of the Honorable Supreme Court.
In SDO Grid, They have not referred to Shail Kumar, is it?
They refer to Shail Kumari, my lord,
But don't.
they don't leave. And the facts were completely different. In Timur Avram's case, my lord, there is a civil suit is filed first. The civil suit gets dismissed. After the dismissal of the civil suit, a writ petition is then referred in the Orissa High Court, asking for compensation. That is, it's on that basis, my lord, that the Honorable Supreme Court, within those facts, deemed it, my lord, of a case not fit for compensation.
It's distinguishable on facts.
On facts, my lord, which is what the division bench has done at para 10.
Yes.
Page 24, my lord, is the.
We'll continue after the division bench matter. Division bench matter will not, should not take much time, so that there's continuity. Otherwise, there's be a long discussion. Yes. Sir. So for us, for judges, you can say strict liability. We have defenses. Dates, if you want, you can take from the court office. You can take a date from the court office. Good one. Huh? Seal number? Yes.
Now the government directed these are open universities. You see that the person now, another university or only the board, the syndicate, and the chancellor. Person of intervention by the government, and that is covered by the budget.
Now there is some interim protection in this matter already. Interim order earlier granted. Interim order earlier granted is extended. This is the matter on 16th, let us see, 16th.
I will serve a copy on
Yes.
So the case where the Bangalore University framed a statute. Government intervened. The legal center was the statutory authority that framed its rules and regulations by means of a statute. The Act says conditional service is regulated by statute. And the question of interference with government is not right.
The government at the most will have some supervisory powers.
Yes. No, they have got a power to issue direction on policy matter. But condition of service, the entire power lies with the university by framing the statute under the Act. That's the position.
This is like the same logic where the division bench said entrustment must be by the government.
Please.
And it cannot be by other than the employer.
Please. But the other 3-4 Supreme Court judgments, where the power to lay down the policy rests with the government.
Rest is with the authority concerned.
Because the statute says, the Act says that the university can frame a statute and prescribe the service conditions. That is the legislative power.
That power is already conferred. Namaste, brother. Yes.
And Lordship sees the order of 21st February 2022. Just read it, right? After hearing both sides, the Senior Council was hearing out for the respondents to submit that an amount of rupees 90 lakhs will be paid by the end of March 2022. It is further submitted that the remaining amount as stipulated in the compromise will be paid at the end of July 2022. An affidavit is to be filed to the said effect, which would contain the details as to the efforts made to sell the property and contain the details regarding the offers received. It clarifies the respondents accused are permitted to take out paper publication. Once again, take all of the steps as may be necessary to alienate property and raise the funds. The submission of the Senior Council appearing with the response accused that they are making serious efforts to raise funds. Irrespective of the sale process of scheduled property is also taken note of. Without expressing your opinion as regard to the timeline put forth by the Senior Council appearing with the response, this is the matter in the first week of April 2022. But neither has this payment of 90 lakhs been made, nor is there any affidavit which we have been supplied of any copy. But to the best of our knowledge, nothing is filed before the court. My humble submission, this is a case of aggravated contempt in the light of the earlier orders and this order.
Now the undertaking, oral undertaking of payment of 90 lakhs is not made good.
Nor is there any affidavit also not filed after this order of 21st February 2022.
May, my lord.
Yes.
May, my lord, I represent, my lord,
Firstly, we would like to observe that your client has changed two senior counsels. And on the first occasion, Mr. Holla had appeared.
Yes, my lord.
And on the second occasion, Shashikiran Shetty had appeared. And during all the proceedings, he was present in video conference. So the undertakings that were made and orders that was passed and indulgence given was in his presence. In fact, he was asked to be present.
He is
so
present.
We find
he is present, my lord.
So for prima facie, we find that this is a case of aggravated contempt.
Only one, my lord. My lord, absolutely, my lord. I bow down, my lord. There's, my lord, the submissions of my learned friend, my lord, that there is non-compliance in respect of, my lord, the previous order passed by this honorable court. My lord, it has not been complied with, my lord. That may be correct. My lord, only one, my lord, grave obstacle, my lord, which is coming in the way, my lord. In fact, I was also, my lord, hesitant to, my lord, appear because, my lord, I was also, my lord, concerned about, my lord, the different lawyers appearing at different points of time. Only one point, my lord, that I, my lord, humbly felt that I should bring it to your lordship's notice, my lord, which appears to be their genuine problem. May I just very humbly take your lordships to page number 55, my lord. Page number 55, my lord. Ink page number 55, my lord. The RFA judgment page number 41. My lord, clause C, my lord. This is what, my lord, putting the prospective bias, my lord, on the back foot. I think the principal bench, my lords, are, my lord. Yes. My lord, the principal bench, my lord, I think the connectivity is lost, my lord. I don't see his lordship's. Yes. Someone must have, my lord, tried to, my lord, change the host, my lord. That's where, my lord, we lose the connectivity sometimes. My lord, the honorable principal bench, my lord, court officer may have to log in.
Yes, yes, yes. They are trying.
Okay.
Yes.
May, my lord. But we
Still connected.
So firstly, what we want you to find out from your client, why is he changing senior counsels like this? It doesn't go good.
It's certainly not a good, my lord, conduct. I bow down, my lord, I agree.
Please inquire.
My lord, I'll put him directly, my lord. He is sitting here, my lord. I'll just put him directly, my lord. He may answer the court's question.
I don't want to converse with him directly when you are there. But only emphasizing that there must be some sanctity. You cannot change senior counsels like change of the hat. It doesn't give a good. I have passed a discretionary order looking at the face of the senior counsel who has appeared before me. And if this is how we don't put everything in writing, what we put in writing is only the what requires to be put in writing. An exercise discretion is by looking at the standing of the senior counsel who comes before the court. And if the client has no, if he is trying to change senior counsels, it becomes difficult for the court to conduct proceedings with appropriate dignity.
I understand. In fact, my lord, if I may humbly submit, my lord, I did, my lord, raise the same question, my lord. It's not fair on my part that previous two senior counsels have appeared and at his instructions, my lord, certain, my lord, undertakings were made to the honorable court. It's not fair. My lord, now I appear, my lord. What I was told, my lord, now, my lord, in fact, he did inquire with the previous senior counsels, my lord. They too have some hesitations with some compliance. My lord, which, my lord, I very humbly, my lord, apologize, my lord. He may be, my lord, given some pardon, my lord. I'll ensure that, my lord, he wouldn't change me also in future, my lord. Otherwise, my lord, no senior advocate may be, my lord, able to represent him. My lord, I understand, my lord, there is such kind of, my lord, an erroneous behavior which may kindly be condoned, which may be prompted by the circumstance.
Now, undertaking not having been complied with, now let it go before the regular bench for framing of charge.
Yes.
Indulgence from the last order, I'll have to recall, and then you go before the
only one indulgence, my lord. Only one indulgence, my lord. It's certainly, my lord. I am here to make my submission. Certainly, my lord. I have nothing to defend. My lord. I have nothing to defend, my lord. We can't, my lord, substantiate such kind of a failure also. But only one, my lord, obstacle that is coming in their way, my lord. My lord, they appears to have had, my lord, 3 prospective buyers, my lord, post, my lord, 5 paper advertisements that were popped. Now, my lord, kindly, my lord, may I just take your lordship, my lord, for a minute to page number 55, my lord. This appears to be, my lord.
That you explained before the court file framing charge. Whatever discretion we have extended, right from the earlier state will stand recalled, and now it will have to go to the same stage as earlier.
Submission, not both councils had submitted. And we had requested your lordships to continue not to monitor. They were not, my request is not, the lordship would be perfect, you not justify in framing charge, requesting it for framing of charges. But it need not go back to the regular bench. Your lordship has heard it in part. Your lordship has passed directions. And it's the request of both councils that we made the request. My request is the lordship may keep it not a framing of charges, but the lordship will continue to deal with the matter. The lordship has heard in detail. All the sufficient and merits your lordship has been taken through. The papers have been taken through. Thereafter, not only after hearing in detail, my lordship has passed this out. Now, my request is not to again put it back before some other bench, in the sense of having to explain right from the beginning, cannot be required. Both of us had expressed. Continue.
Correct. Now
Even my humble submission, my lord, with folded hands would be that my lords may kindly retain the matter. And my lord, in so far as framing of the charges, my lord, I would, my lord, very humbly submit, but certainly, my lord, it is not a willful contempt or willful disobedience. The only thing, my lord, which is coming in their way, only one moment, 1 minute, my lord, I will just take, my lord, pray for the indulgence of your lordship. Page number 55, my lord, the confusion which is prevailing, my lord, which is coming in the way. my lord, putting the buyers on the back foot. Now, my lord, page number 55, my lord, internal, my lord, internal page number 41, ink page number 55, paragraph number C, my lord. It is further, my lord, are my lords, are
Yes,
my lord?
yes.
It is further agreed, my lord. This is what something that equipped them to, my lord, have, my lord, a fair, my lord, avenue to, my lord, raise some monies. Now, my lord, the paragraph number C, my lord, is quite contradictory. It is further agreed.
Shamsundar,
Yes, my lord.
no amount of explanation, but you are not in a position to make good. So no amount of explanation.
No, my lord, I have, my lord, advised them to certainly.
This has been argued before your lordship. My lord, we had said we'll cooperate in any way. Till now, my lord, what are those offers which have come before? Your lordship had asked him to prepare an affidavit, setting out the efforts. What are those offers? But he had pointed out, if your lordship recollects, but in January, they made a submission before your lordship. The buyers are coming with a bid of only 5 or 6 crores. He made a submission, please sell it at 12 or 6 crores. Not wanting to sell the property at that rate. He's wanting to keep on us on the waiting. And in fact, my mother passed away in the meanwhile, not without seeing the fruits of the decree. My mother passed away. I had already pointed out to your lordship earlier. She was about 90 years old, but she passed away now in the meantime. But all oral submissions are being made without placing an affidavit before your lordship as required in the 21 to 22 order. In fact, this is a contempt not only of the earlier order, of the order of 21 to 22. How could there be not any difficulty in filing an affidavit?
No,
Setting out
absolutely.
What are the offers received? Who are those buyers? But are they even aware whether they have made those applications? Nothing.
And if not a buyer has come for 6 crores, 7 crores, nothing prevented him from making selling and paying the amount.
He cannot not say, I will wait for a better offer to come and keep pushing it.
No, it certainly it is not for the better offer. May I, my lord, just practically show one thing, my lord. I agree with my learned friend. Even the affidavit is ready, my lord. This is the actual problem, my lord. It's only 1 minute, my lord. I may just, my lord, make an attempt to impress upon your lordship. Paragraph number C, my lord, on page number 55. It is further agreed that to enable respondent number 2 to 8 to pay the second family arrangement amount of rupees 12 crore 50 lakhs to the appellant. Respondent number 9 to 12, 14 to 16, it is agreed between them that the respondent number 3 is permitted to negotiate with the third parties. However, he shall not in any way without the written consent of the appellant enter into any agreement with any such third party or sell schedule pre-property. Well, till here it is okay. Without ensuring full payment of second family arrangement amount of rupees 12 crore 50 lakhs. Now the buyers are asking us that unless you pay this 12 crore 50 lakh rupees, you can't even make an attempt to sell this property, my lord. Two portions of this, my lord, paragraph are, my lord, quite self-contradictory. The first portion says, it is in order to, my lord, make an attempt to, my lord, pay off this money, I would be, my lord, entitled to negotiate for sale of, my lord, this Schedule B property. The second part would say, my lord, that unless and until I ensure that 12 crore 50 lakh rupees is paid off, that I can't even make an attempt, my lord. This is what is coming in our way, my lord. We have, I think, filed a memo, my lord, with the paper advertisements which we have carried out. My lord, we have carried out, I'm instructed to say, we have, my lord, put paper advertisement in 3 major newspapers. And, my lord, we have had some offers, my lord, which shall be, affidavit is ready, my lord. I am instructed to say, my lord, they will be placing. My lord, this is what is putting us on the back foot.
This is totally unacceptable. How do you say affidavit is not filed? Is this the seriousness with which contempt proceedings are treated? I'm sorry. There's absolutely no respect for the court or its dignity. If affidavit is not filed, even on the date matter is listed for contempt, how can we listen to you? Absolutely unacceptable. No, you can, we'll go ahead with the matter. Absolutely no ground made out any indulgence.
Only one, my lord, indulgence, my lord, one short accommodation may kindly be given.
With due regard, I am last person to lose my patience, but this is a case with the very fact of changing of senior counsels and non-adherence to the spirit of discretion is contemptuous. Lee said
but their own statement of making 90 lakhs by the end of March is not complete. It was their statement, not whereas we had requested the lordship to point out at least 20% of the check amount which is to be paid at least that be paid. Your Lordship is not kind enough to say, all right, since he's making the statement, he'll pay 90 lakhs by then. That is their own statement.
Yes.
Even that, not, I would humbly submit, not they are not entitled to write up audience without making their own submissions and without complying the order. They should purge themselves of this contempt, my lord, of the order of 21/2/22. Not only is my lord filing an affidavit, they have to make the payment, my lord. It was to be paid by 31st March, by the end of March. Now, my lord, we are and no statement is being made about the payment being made even today. But I am sorry, not this is, as the Lordship not also pointed out, this is completely against the majesty of the law and the courts. But at the, I'm sorry to submit, that the accused seems to be feeling that he can simply make statements and keep on dragging on the matter and not see not the force of the law. But the Lordship asked even the other accused to be present. All of them have given undertaking.
So now there are two options available. One is insofar as it was before indulgence was shown. Now, the intervening circumstances, the options available are to treat it as an act of aggravated contempt and seek the register to register suo motu contempt. One. Two, it would be open for you to initiate a fresh proceedings. It may not merely be one of disobedience, but one of abuse of the process of the court. And in which event it would be a contempt under 2B, 2C. C.
Yes. See.
The other three options that are available insofar as the subject is concerned. So how do we?
My submission will not. This would be contempt in the face of the court. The subsequent because it is in the face of your Lordship's order. But your Lordship would be entitled to take cognizance. Your Lordship would therefore not post the framing of charges against insofar as the original contempt as well as contempt in the face of the court, which your Lordship would take cognizance of. But and as for not all the accused to be personally present, not before Lordship, to ensure the that the process of the court is stopped. But it would be required not they be personally present, and then charges be framed.
But we cannot only practical difficulties with the other judge there.
I do understand. At your Lordship's convenience, not any Friday, even at the towards the end of the proceedings, since you should not disturb your Lordship's regular schedule, either of the places. Lordship has heard this, and now, this is in the case of your Lordship's order. Therefore, it would be appropriate, especially when both sides have earlier submitted, that your Lordship should continue to monitor. Your Lordship, in fact, the order also states that the monitor the progress on the order of 21/12/21. Your Lordship had considered that.
My lord, my humble prayer, my lords, may kindly, my lord, retain matter, my lord, before this bench alone. Now, my lord, I have also now, my lord, advised them, my lord, they have also seen, my lord, the serious, my lord, dissatisfaction of the honorable court. Now, my lord, I don't think, my lord, anyone else maybe have any help for him, my lord, if this continues, my lord, he has it in his mind, my lords, may kindly accommodate him, my lord, by few days, my lord. At the end of the day, the idea is to, my lord, certainly to settle this matter, my lord, which is certainly, my lord, arising out of a compromise decree, my lord. At the end of the day, my lord, they're all family members, my lords, may kindly show him pardon, my lord. It's my prayer, my lord. It's my prayer, my lord, if the matter goes before some other bench, my lord, this matter may go. May we can, my lord, for that, my lord, reason, I would like to, my lord, be on the side of my learned friend. My lord, I do, my lord, concede that certainly, my lord, it is a repeated act of contempt. My lord, the only difficulty what they have told me, my lord, is this particular portion is coming, my lord, it is putting the, my lord, prospective buyers on the back foot, my lord. I was only, my lord, preparing to, my lord, make this submission, my lords, may kindly accommodate them as a last warning with some reprimands and strictures, my lord, accommodate them sometime, see to that, my lord, I will, my lord, advise them to somehow or the other, my lord, satisfy, my lord, the decree. My lord, this is my prayer, my lord. So, my lord, so that, my lord, he is aware, my lord, today, my lord, what could be the consequences of, my lord, a further act of contempt, my lord. It's my only prayer, my lord, may kindly accommodate them. And it's my prayer with learned friend also. I have certainly nothing to, my lord, contest in this matter. My lord, I am also aware, my lord, he is also here, he is also aware, my lord, the condition of, my lord, the seriousness of the matter.
On 21/12/2021, they have granted permission to sell. What comes into the...
In fact, Lord, I may point out this
What comes
explanation.
in? What comes in?
Because
What
in his, Mr. Johnson, just with your permission, right? He has filed an application where he agrees, Lord, after the sale is concluded, the title should be handed over. He has himself filed an application. Lord, this statement which is being made is another excuse. At no point of time he has approached us and said there is any cooperation required from us. We are required to show any title document. Nothing. Lord, this statement is again being made across the bar without any affidavit. Which buyer has said so that he is not willing to sell it? But I suspect not this the authenticity of the statement being made without anything from any buyer. Nothing has been brought to our notice.
May I pray, my lord, I concede my learned friend, my lord. Yes, it is, my lord, the fault on the part of, my lord, the accused and, my lord, the advocate on record that they have failed to place the affidavit. My lord,
I also point out, at the sake of repetition, in para 8 of the earlier affidavit, he said, I will sell the scheduled property or liquidate other assets in order to comply. Nothing has been done.
My lord, I will see to that, my lord. I will see to that, my lord, by tomorrow business, close of the business hours, my lord, a detailed affidavit is placed. My lord, may kindly have it, my lord, next week sometime, my lord, we will make certain, I will advise them to make the proper undertakings, my lord.
I listed for framing of charge.
My lord, another breach.
I listed for framing of charge next Friday. Meanwhile, we will work it out with the client.
We will file, my lord, detailed affidavit, my lord, in the meanwhile.
Here affidavit will not suffice. They have to comply with the earlier order of 90 lakhs payment. That also has not been done.
This court.
You can file place a memo also not of non-compliance with the earlier order.
It is noticed.
He sent an email to the registry.
Yes.
Produce the memo of non-compliance. Filed by the counsel for the complainant. It is a notice that this court, by order dated 21/2/22, had taken note of the submission made for the respondent accused that the amount of rupees 90 lakhs would be paid by the end of March 2022 and that the remaining amount would be paid by end of July 2022. Further, it was observed that an affidavit was to be filed, which would contain the details as to the efforts made to sell the property and details regarding offers received. Full stop. The further submission of learned senior counsel appearing for the respondents accused that the serious efforts to raise funds, irrespective of the sale process of Schedule B property, was also taken note of. The matter was adjourned to be listed in the first week of April. Next. The memo of non-compliance would reveal that the further payment of rupees 90 lakhs as undertaken by the end of March 2020 is not complied with. Neither any affidavit to the effect as noticed in the order of 21/2/2022, has been filed. Next. It is to be noticed that this court while noticing the default at the first instance, after hearing the counsel for the accused and senior counsel representing him had afforded an opportunity to petition, make good contempt at the first instance, affording an opportunity to make payments as per the settlement put forth before the court. Indulgence was shown and extended time was granted to make payments. After granting permission to alienate Schedule B property and deposit proceeds. In fact, affidavit 15/12/21 affidavit was filed. Anjana, 15/12/21. Affidavit was filed on 15/12/2021, wherein the accused had proposed to adhere to the earlier undertaking made before this, and also detailing steps to be taken for sale of Schedule B property.
At least para 8, where he had said he would sell this or other liquidate other assets. The affidavit of
Paragraph 4 of the affidavit, the accused had submitted that 50 lakhs to be paid within a period of 15 and a further sum of 50 lakhs within a period of 25 days thereafter. That has been complied.
That has been complied. Thereafter, one more affidavit was filed on 21/12. 21/12.
Though the initial payment has been made, the further undertaking made before this court as per the order
21/2/22.
21/20 non-complied. Neither is affidavit as directed the affidavit order dated 21/2/20 filed. Clearly, the default made subsequently is an act of contempt in the face of the court. This is apart from the contempt complained of in the petition. Prima facie, no case is made out for extending any further discretion and taking note of the series of orders passed by this court and indulgence shown and affidavits filed. We find no reason to extend any further indulgence, and matter is posted for framing of charges. All accused to be present on the next date. List the matter on next Friday.
May I request for the leave to place an affidavit in the meanwhile?
You file.
I am so
Yes.
grateful.
Yes, brother.
Thank you.
I'm so grateful, my lord. Once again, my lord, I apologize, my lord, for this kind of, my lord. I would rather call it as violence on the honorable court, my lord. My lords may kindly accept my apologies for.
Oh, now how we can? What is the urgency? What will happen? What will happen between today and Monday? Huh? Who is the employer? Who is the employer? Of BESCOM. Any counsel for BESCOM? No. You just take instructions. Matter of premature transfer is what they say. So when do you want it? Tuesday. This is the matter on Tuesday.
With my lords, kind leave, my lords.
Yes.
Serial number 40, my lords, may seek for a week's time. I appear for the petitioner, my lords. I've informed the other side also.
At request of the petitioner, list the matter week after next.
Obliged.
Yes. ಯಾವುದು 20? Just 5 minutes. Yes.
With your lordship's kind leave, my lord. My lord, serial number 40, the petitioner has taken adjournment. I appear for petitioner in 40.1, my lord.
It won't reach today. That's why we have adjourned.
Yes, ma'am.
So urgent-
Date may, there's some urgency, my lord. I may
Let's see,
seek for fixation of a date, my lord.
Yes, we'll see. But not it, Manjuna. The date. Yes. Now there are two appeals, is it? Accused is common. What are the offense complaints? What are the offenses?
The offences and the books are later on during the charge sheet, they have included SC/ST action. My case.
This one. So what is the approximate period of conclusion of evidence?
3 months or 4 months. The remaining witnesses are doctors and police officers and police officers.
My lord, actually there are about 50 witnesses still left. This honorable court had given a direction 2.5 years ago to complete the trial within 1 year. That has not happened.
Order dated? Order dated? Let us see. 20.
Both cases, both petition had been filed and with liberty they were withdrawn. At that time, this honorable court had given the direction.
You have a copy of the order?
Right, the memo dated 11th April 22.
Yes. Yes, 11th April. Yes.
My lord, the most important witness has already examined and cross-examined as well. And in both of them, she has said this petitioner has not troubled her. Very peculiar things have happened, my lord, in this case. At the time of trial, even before the trial, my lord, initially one fee who had been adopted came back within 15 days to the shelter home maintained by this petitioner, my lord. When she came back within 15 days from her adopted parents, the child protection officer counseled her. And during the counseling, she informed that A1, not this petition, A1 had bad things with not her, but the 3 other girls. Some other 3 girls, not the person who gave the information. So the police registered FIR against A1. And during the course of investigation, the girl who had mentioned 3 names, the names of 3 other girls, those 3 girls were inquired, and one of the girls, by name K, she made allegations about this plaintiff. Thereafter, my lord, strangely, 164 statement of that K was taken, my lord, and she does not make any allegations against this petitioner. For strange reasons, once again, one more 164 statement was taken, my lord. In that, she has made allegations against the petitioner.
Where are the 2 statements?
My lord, there are 2 in the memo filed on 11th April 2021 was memo is there. In that, my lord.
In which matter?
In 247.
There is one memo filed on 28th March in 247. Good. No, there is a 28th. Could you?
This is in 251, my lord. On 13th May 2019, 164 statement was taken, there was nothing. Further, on 164 statement, she makes allegations on 15th May 2019. Sorry, however, on 18th May, once again it was taken, and she makes allegations against the petition. There is much more, my lord, same things that have happened.
Now we are not so much on the merits. Now we are not. Now the main evidence of the main witnesses is complete. It's only the official witness. I'll come to you. Page number. Page number. Page 51. 12 of FOXO. And then 21-2. Could you put back? And what about 20 and 21? 12 and 21. 12 is 3 years. Then one year or with fine. Then the third one. Which then we'll enlarge them. What about the other matter?
Allegation is concerned about
No, just one. Now, under 3(1) of the Atrocities Act, what is the punishment? Atrocities Act. No, just tell what the punishment. B1W1 Roman 2.
not be less than 6 months, but it's very extended to 5 years. Until 5.
Now, this is the same in both the cases or different charges. Yes. There. That's a different victim. Victim is different, isn't it? But then 2 years have lapsed then.
3 years.
No, we are not saying that strictly speaking, but what we are saying, we have permitted him to withdraw, be on the ground that it would be completed expeditiously. Now, more than approximately 3 years, trial is not completed. So we just, and the main witnesses are complete. Correct. In both the matters. Then we can enlarge. There's no threat to the witnesses as such. Now the victim and other witnesses have been examined and cross-examined. What
possibility of
one nimsham, so what remains is only insofar as the official witnesses are concerned. So we'll enlarge him on bail, then the rest is a matter for trial. The trial, whatever the judgment takes, it takes. Except EW5 has $265 of 265. So except that witness, everybody else is supported, is what you have said.
This allegation against
260. Yes. Yes. So the present case is relating to the accused number. What has happened to accused number 1? So the first matter will enlarge him on bail. First matter. So what do you have to say? What further in first matter? 247.
247. Why not I have a number information? Actually, we given the information. So as based upon the use of P, this protection officer has given the information, and based upon that, the FIR is registered. What is said by that girl in that case is that some 3 girls have been abused by A1. Now that FIR was sufficient for everything. Instead, when one of the girls was her statement was taken, she made a complaint about A2, and now A2 is accused both in A1 and slide number 14 and 16. There is only one incident against this accused, but there are 2 FIRs, 2 claims, and 2 trials going on simultaneously. As to this, and then my lord, my kindly present my a little bit how he has been victimized.
That we'll see later. Now, what we are saying is only on the ground that the major witnesses have been examined.
No. This is something fresh.
Only we'll pass an order. The more we talk of merits, it will prejudice either the prosecution or you. We don't want to enter into the merits. We propose to enlarge you on the bail on the only ground that the main witnesses have been examined and cross-examined. What remains is the examination of the official witness. In the first matter, all the offences are punishable below 5 years. First case. Only on that ground we'll say that and leave it at that and enlarge him on bail in the first matter. Second matter, we'll see what it is. You are in custody since?
3 years, 3 months. 14/3/2019, my lord.
Petition. No, the appellant has called in question correctness of the order dated 30th August 2021, whereby the application to be enlarged on bail by accused number 2 came to be rejected. The petitioner is seeking to be enlarged on bail as regards his continued detention pursuant to the registration of FIR in crime number first matter
14 of 2019.
14 of 2019 pending trial for the 14 ಅಲ್ಲ ಇದು 16 ಇರಬೇಕು ಕರೆಕ್ಟಾ ಅಲ್ಲ 376 ಇರೋದು ಯಾವ ಮ್ಯಾಟರ್
247 is in crime number 14.
376 is in which matter ಯಾವ್ದ್ರಲ್ಲಿ ಬಟ್ ಇಲ್ಲಿ ಇವರು ಬರ್ದಿರೋದು 14 ಅಂತ ಇದೆ page 4 of the appeal memo. You have said 376 in 14. POCSO and 3 of Atrocities Act and 12 of POCSO is which crime number? Correct. So what are the offenses in crime number 14? So then we correct. So first. So then we'll take the. ಎರಡರಲ್ಲೂ 376 ಇದೆಯಾ? Well, 21 and okay. So we'll first consider 14. Same but 14 of 2019. 14 of full stop. 14 of 2. Though the FIR was registered with respect to the offences of 376I Renkaradya and of IPC and 5 and 6 of Protection of Children from Sexual Offences Act 2012. While framing of charges, isn't it? Charges were framed only with respect to the offences under section 247.
47 charges.
You go to page 51. This is what you pointed out. So the charges were framed only with respect to section 12 of POCSO, section 21(12) of POCSO, and 3(1)W, Roman 1, Roman 2 of Scheduled Caste and Scheduled Tribe, within brackets Prevention of Atrocities Act 1989. It is a contention of the counsel for the petitioner that petitioner has been in custody since 14/3/2019. Counsel, we're in custody in this case since 14/3/2019, and that offense under section 12 is punishable up to an imprisonment of 3 years, 21(2) with up to 1 year or with fine, and section 3(1) of the Atrocities Act up to 5 years. It is contended that the so this is 68, isn't it? Yes. It is further contended that the victim and other main witnesses have been examined and cross-examined, as is evident from the memo filed by the prosecution, which indicates that 12 witnesses have been examined and cross-examined. Accordingly, it is submitted that the petitioner is entitled to be enlarged on bail. On behalf of the prosecution, it is pointed out that the main allegation is as regards accused number 1. And insofar as the present accused is concerned, trial is at an advanced stage, and the trial itself may be permitted to be concluded expeditiously. The counsel for the petitioner has further relied on the observation made in the previous criminal petition. In criminal petition 6676 of 2019 and 7543 of 2019, wherein the petitions were disposed of while observing that the special court was required to conclude the trial under section 35(2) of the POCSO Act. Conclude the trial keeping in mind the mandate under section 35(2) of the POCSO Act. And it is submitted that though the order was passed on 22nd of January 2020, trial has not yet been concluded. It's heard both sides. the case of the prosecution is that an inmate of a Spurti Dama shelter home for destitute children was given in adoption to CW 30 and 31. And the child was returned back by the adopted parents to Spurti Dama. The child, when being counseled, had revealed that Hanmantappa used to visit Spurti Dama and is stated to have had sexual intercourse with other girls. It is further submitted that during the course of investigation, the authorities, during the course of investigation, the investigating authorities have come across material to implicate the appellant herein, and accordingly, charge sheet has been filed after investigation. Admittedly, the charges as against the petitioner in the present case is only under section 12, 21(2), 12 and 21(2) of POCSO and 3(1) of the Atrocities Act. The said offences are punishable as follows. Clearly, the maximum punishment that could be imposed is as regards the offence of 3 of the Atrocities Act, which is an imprisonment of up to 5 years. Less than 6 months and up to 5 years. Next. The petitioner has been in custody since 14/3/2019 and accordingly has been in custody for more than 3 years. Next. According to the memo filed by the HCGP appearing for the state, insofar as the present case is concerned, 12 witnesses have been examined and cross-examined, and the witnesses, including the victim, isn't it, has been examined and cross-examined. The main witnesses supporting the case of the prosecution have been examined. What remains in the trial is only as regards official witnesses. It must be noted that this court had observed that the mandate of 35(2) of the POCSO Act requires conclusion, expeditious conclusion. But what does it say, 35(2)? No, I'm not on the point of law, but I'm saying it says evidence trial should be concluded in which provides that trial should be concluded within a period of 1 year. Now, we do not intend to enter into the time period and its implication, but noticing that the petitioner has been in custody for 3 years, 2 months, and that the trial has not concluded, and also looking into the punishment prescribed. Any further continuance may result in petitioner completing his sentence even before judgment is passed by the trial court, which possibility cannot be ruled out. Next. Taking note of the peculiar facts wherein though the trial is at an advanced stage and taking note of the punishment prescribed and noticing that the present proceedings cannot be treated to be punitive in nature. The contention of the prosecution that petitioner should be continued in custody till conclusion of trial is not warranted. The counsel for the petitioner appellant has also contended that there are two 164 statements, and the first statement under 164 recorded of the victim does not make any imputation against the appellant. It is also a matter that cannot be brushed aside, though the recording of the second 164 statement requires to be appreciated during trial, as it is stated that the second 164 statement implicates the appellant. Accordingly, taking note that the order appealed is also of 30th August 21 and the petitioner is appellant is continued to be in custody. In light of the discussion as made above, petitioner is entitled to be enlarged on bail conditions. What are the conditions? Normal conditions. Okay, now come to the next one. Now, in this case, what are the FIR? What is the charge? What is the charge? Yes. What is the punishment? Yes. Then yes. Six. No. 21-2. Yes. This is a little serious. What is the stage? What is the stage of this trial? This is 69 of 2019, isn't it? So, official witness. So now on merits in this case, anything? Make it simple and fast.
Very simple.
Page
219.
Yes.
It starts from the victim girl Mela. Start from 217,
Yes.
but the relevant portion is 219.
Yes. Yes.
When it was being exotic, it was a little bit uneasy and reluctant to divorce. But the honorable judge has assured that he wanted to release actually ಎಲ್ಲರಿಗೆ ಆಗುತ್ತದೆ ಅಂತ ಹೇಳ್ತಾ ಸಮಯ ಕೊಡ್ತಾ ಅಂತಾರೆ. ಎಲ್ಲ ಉದ್ಯೋಗಿಗಳು ಮತ್ತು ಪೀಠಿಗಳನ್ನು ಹೊರಗಡೆ ಕಳಿಸಿ ಒಬ್ಬರು ಇಲ್ಲ ಸಂಗತಿಯ ಬಗ್ಗೆ ಸಾಕ್ಷ್ಯ ನುಡಿಯಲು ಬೇಗ ನುಡಿ ಹೇಳಿದಾಗ ಇವತ್ತೇ ಸಾಕ್ಷ್ಯ ನುಡಿಯುವುದಾಗಿ ಹೇಳ್ತಾರೆ. Please kindly come to the last sentence.
Yes.
ಒಂದನೇ ಆರೋಪಿಯನ್ನು ಬಿಟ್ಟು ಬೇರೆ ಯಾರೂ ಈ ರೀತಿ ತೊಂದರೆ ಕೊಟ್ಟಿಲ್ಲ. This is what she has said, my lord. Not only that, my next page, my lord. 220, second paragraph. ಸದರಿ ಸ್ಫೂರ್ತಿದಾನದಲ್ಲಿ ನಾನು ಇರುವ ಸಮಯದಲ್ಲಿ ಎರಡನೇ ಆರೋಪಿ ಸಂಖ್ಯೆಯನ್ನು ನೋಡುತ್ತಿದ್ದರು. ಎರಡನೇ ಆರೋಪಿಯಿಂದ ನನಗೆ ಯಾವುದೇ ತೊಂದರೆ ಆಗುತ್ತಿಲ್ಲ. Unfortunately, my lord, our reasons, the learned SFPP has stopped the further preparation. That day itself, as soon as this girl has stated this, and then it has continued on further, sometime later on, but there again she makes allegations against it. Subsequently, my lord, since she dead, she has been a tutor and she is again makes allegations. My lord, let I would bring your attention to page number 227 and 228.
227.
Let us come to 225 now, please.
No, so you are saying that the first statement stating that accused number 2 did not do anything, then she has given something against.
Yes.
That's all.
Yes. Which is examination. But again, in the cross-examination also, she has similarly said nothing has happened to me from accused number 2. 227 and 228.
227
and 228.
I just point out that.
227, my lord.
Yes.
He has been asked. There were so many officials, doctors, police officials, often coming to the place for verification and other things. She is asked whether you had any difficulty in complaining about this man. She says no, I had no difficulty. Not because nothing has happened, she has not complained. And then, my lord,
Just point out to that portion which you says cross-exam.
in the cross-examination for accused number 1, matter 221.
Yes.
ಪ್ರಥಮ ಬಾರಿ ಮುಖ್ಯ ವಿಚಾರಣೆಯಲ್ಲಿ ಎರಡನೇ ಆರೋಪಿ ಬಗ್ಗೆ ಸತ್ಯಾಗಿ ಅವರು what was related the first time chief examination in chief that he has done nothing to me. That was once again asked to her whether it was true what you stated there, and she says yes, my lord.
Now, in this case, what do you say? Now, the rest is a matter for trial. He's in custody for 3 years. Yes. Yes. No, any of that is a matter for trial. He's been in custody for 3 years. You complete the trial and let him face the sentence. Yes. Appellant has called in question the correctness of the order passed in special case number 69 of 2018, dated 30th August 2021, and it seeks for enlarging the appellant on bail. In light of his continued detention. This is 251, isn't it? It is 251, tane? So in this it is 69. 69? 60? A special case? Imperial 68 ಅಂತ ಇದೆ. This is 69. So the third line is 69, isn't it? 69 of 2019. In the business. Detention as regards proceedings in crime number 16 of 2019, registered for the offences punishable under 376(3), 506, 5 FOPL 6, 21(2) of POCSO and 3(1), 3(2) as it is, of Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act 1989. Is the case of the prosecution that the complainant was residing in Spurti Dama and one Hanumantappa used to come to the girls' hostel to visit a girl who was a resident of Spurti Dama, who introduced the said Hanumantappa to her. It is further made out in the complaint that Hanumantappa had lured the complainant that he would marry her and committed sexual offences on her. And that they said Hanumantappa was committing similar offences against other inmates. In light of allegations made against said Hanumantappa, FIR was lodged. So FIR was initially lodged only against Hanumantappa. And during the course of investigation, FIR was lodged also against the appellant on the basis of allegation made in the complaint that appellant had also committed sexual offences along with the other accused. Investigation is complete. Charge sheet has been filed. The charges aimed against the appellant, the page 54 is the firstly, secondly, and offences. Firstly, secondly, 56, page 4 to 54 onwards. Next, it is submitted that the petitioner has been in custody since same date arrest. Since 3 years, 2 months. That the trial is at an advanced stage. 11 witnesses have been examined, and the victim and other important witnesses have already been examined. It is the further case of the appellant that during trial, the victim in the examination in chief recorded on 9/10/2020 after had expressed hesitancy to continue the evidence and on being pacified by the presiding officer, the victim has remarked that except the first accused, nobody else had troubled her. It is further emphatically made out in the examination in chief that second accused who was running the institution had not troubled her in any manner. He submitted that at the intervention of the public prosecutor, evidence was deferred, and on the next date, that is 4/12/2020, the witness has made certain imputations against the appellant, contrary to the earlier evidence recorded on 9/10/2020. Accordingly, it is submitted there are contradictions in the evidence which needs to be sorted out in trial. And public learned HCGP appearing for the state, on the other hand, submits that in the further evidence and examination in chief recorded on 4/12/2020, the victim has stood her ground while making allegations against the appellant, and that the contradictions in the cross-examination recorded later are all matters to be considered in trial and cannot be looked into at the present stage. It is further submitted that trial itself can be concluded expeditiously. Heard both sides. Must be noted that this court, in the order passed earlier, just give that memo that's in the other file. Orders good. In the earlier orders passed in criminal petition so and so had observed that trial was required to be concluded expeditiously, taking note of the mandate under 35(2) of the POCSO Act. Though a period of more than 2 years has elapsed, trial still remains to be concluded. As per the memo filed by the learned HCGP, insofar as the special case 69 of 2019, 11 witnesses, including the victim, have been examined and cross-examined. The witnesses, admittedly, the only witnesses who remain to be inquired into are the public witnesses. The petitioner has been in custody since 3 years and 2 months. The present proceedings cannot be treated to be punitive. The main witnesses of the prosecution having been examined, there is no warrant for continued detention of the appellant. The appreciation of evidence is a matter best to be left for trial. It must be noticed that the appellant has been enlarged on bail in the other matter by order passed in criminal appeal so and so on this day. Next. The presence of the accused should be ensured by imposing appropriate conditions. Accordingly, the appeal is allowed. The appellant is entitled to be allowed. Yes. Nine only. Number 9. Passport. ಈ ಪಾಸ್ಪೋರ್ಟ್ ಇದೆಯಾ? ಇದೆ. ಒಂದ್ಸತಿ ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಬಿಟ್ಟು ಹೇಳಿ. You just call the counsel for the petitioner. You ask him to ascertain and verify ಮಾಡಿ ಹೇಳ್ಬಿಡಿ. Then ನೋಡೋಣ. You verify from him and inform. If he has, then we'll impose that condition. The passport, the passport of the petitioner to surrender it before the trial court. He must be having, but so we'll impose that. If he doesn't have, that condition won't apply. But you inform the other side that we have imposed this condition. Yes. I will not tell this, okay, a condition imposed for the annual condition. Yes.
17. 34.
Third judgment idea.
Yes.
That decision, my lord, of the division bench has been upheld in the Supreme Court.
Supreme Court.
Yes, page 20.
Yes.
Page 24, madam. This is in special leave to appeal, civil number 3295 to 3299 of 2011, page 24. The decision is dated 17th of October 2013. But as you see, it's a very short order. We do not see any reason to interfere with the order included in the special leave petitions, except to the extent that the rate of interest awarded to the High Court shall stand reduced from 9% to 6% per annum from the date the time granted by the High Court to deposit expires till actual deposit payment of the amount. The amount of rupees 2 lakh deposited by the petitioners in this court pursuant to the order passed by this court shall also be remitted to the High Court for disbursing the same to the respondents. We further direct that the petitioners should be free to seek such redress as may be permissible in law against Sri Satya Prakash alias Satya Goyal, the alleged joint tortfeasor. Special leave petitions are disposed of with the above modification.
Now, this is a person who had put the hook.
Illegally electrified the fence.
That liberty was reserved.
There are two more decisions of the Supreme Court which I wanted to place balance on. Page 68.
Page
68. Parvati Devi versus Commissioner of Police, Delhi. A very short term. The appellants moved the High Court of Delhi, claiming compensation as the husband of appellant one died on account of electrocution while walking on the road. That the death was an account of electric shock is established in view of the CFSL report from Calcutta. But as the appellants could not produce relevant materials indicating the negligence of any particular officer of the authority, the High Court refused to award compensation. It's against this order the present appeal has been filed. Once it is established that the death occurred on account of electrocution while walking on the road, necessarily the authority concerned must be held to be negligent, and therefore, in the case of that, it would be NDMC which will be responsible for the death in question. It is found that from the records that the appellant was serving as a machine man and a statesman and was 54 years as on the date of death, and the age of retirement is 60 years. Taking these factors into consideration, we direct the appellants who are the legal heirs of the deceased be awarded a compensation to the tune of 1 lakh, and NDMC shall pay the same within 3 months from today, feeling which it will carry interest at the rate of 12%. This should be in total satisfaction of the compensation to the legal heirs of the deceased. This was in 2000. Subsequently, there are two decisions of the Supreme Court in regard to compensation. Now, one came from Himachal Pradesh, and the other was from Haryana. I'll first start with the Himachal Pradesh judgment. If I could take my lords also through the High Court judgment, it's a very well reasoned order. It starts at page 26. I want to please see paras 4 from 4 onwards. The law on the point is considered. The various provisions of the 2000 Act.
Yes.
Dhawan Kumar. Thereafter, my lord, please come to page 47, para 36. Para 11, sorry, page 31, para 11.
Page 30.
31.
Yes.
The combined reading of the Electricity Act and the rules framed thereunder and the Electricity Rules of 1956 quoted here and above provide safety measures must be required to be observed for supply of electricity. The electricity is a dangerous commodity and it is the statutory duty of the person responsible for the supply and maintenance to abide by all the protective measures. In case respondents in the present case had installed all the safety devices and had taken precautions, the accident would have been avoided. Thereafter, my lord, at page 36, insofar as my petitioners are concerned, the petitioner's wife represent. Page 47, para 36. In case of MP State Road Transport Corporation versus Abdul Rahman, reported in the year 1997.
Where are you reading?
Para 36, at the middle of the page. Page 47. I'm sorry.
Page 47 at paragraph 36.
36.
Yes.
In the case of MP State Road Transport Corporation versus Abdul Rahman, reported in year 1997, MP 248, the division benches held that the concept of contributory negligence cannot be made applicable to a child. A child functions according to his own reasoning and his intelligence. The reason I am making this argument as well, my lord, this is over and above the argument on Shell. When it comes to children, in any way, my lord, negligence cannot be attributed. One of the petitions, my lord, is a 7-year-old child who is electrocuted by a high tension wire. And that to attribute any kind of negligence, my lord, would be absolutely untenable, and it will also be contrary to the law, my lord. So the law is settled at least insofar as children is concerned. But this, my lord, the court thereafter, my lord, actually considers several other orders insofar as this is concerned, and then comes to Shail Kumari at para 39. Para 39, page 49.
Yes.
The Lordships of the Honorable Supreme Court in the case of MP Electricity Board versus Shail Kumari, reported in year 2002 SC 551, has held that the responsibility to supply electric energy in a particular locality was statutorily conferred on the board. If the energy so transmitted causes injury or death of a human being, gets unknowingly trapped, the primary liability to compensate the sufferer is that of the supply of the electric energy. The Lordships has further held that the board is also liable under the strict liability rule, and the basis of such liability, foreseeable risk inherent in the very nature. So this principle, my lord, is applied in this judgment. At para 40, my lord, the reference is made to HSCB as well, the second judgment that I quoted. Para 40 over the page. In para 39, my lord, extracted as the relevant portion from Shail Kumari.
Yes. It's only an extract.
Please. At para 40, my lord, HSCB is again cited.
Yes.
And even that is extracted. Just to point out, my lord, the relief that is being sought is in public remedy. Ilabati Bera is the authority. It is quoted ad verbatim, my lord, in para 42. Para 42 over the page, my lord, page 51.
Yes, read.
Yes. Their Lordships of the Honorable Supreme Court in the case of Nilabati Behra versus State of Orissa, reported in 1983, Volume 2 SCC 746, have held that a claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed in the Constitution, is an acknowledged remedy for enforcement and protection of such rights, and such a claim is based on strict liability made by resorting to a constitutional remedy provided for enforcement of a fundamental right. It has been held as follows. Could I please just read what it follows that a claim in public law for compensation for contravention of human rights and fundamental freedoms, the protection of which is guaranteed in the Constitution, is an acknowledged remedy for enforcement and protection of such rights, and such a claim is based on strict liability made by resorting to a constitutional remedy provided for the enforcement of a fundamental right, is distinct from and in addition to the remedy in private law for damages for the tort resulting from the contravention of the fundamental right. Civil court remedy, my lord, would be private tort. That would be private law remedy.
Yes.
The defense of sovereign immunity being inapplicable and alien to the concept of guarantee of fundamental rights, there can be no question of such a defense being available in the constitutional remedy. It is this principle which justifies award of monetary compensation for contravention of fundamental rights guaranteed by the Constitution. And that is the only practicable mode of redress available for the contravention made by the state or its servants in the purported exercises of their powers. An enforcement of a fundamental right is claimed by resort to the remedy in public law under the Constitution by recourse to Articles 32 and 226 of the Constitution. This was what was indicated in Rudalcha and is the basis of the subsequent decisions in which compensation was awarded under Articles 32 and 226 of the Constitution for contravention of fundamental rights. The public law proceedings serve a different purpose than the private law proceedings. The relief of monetary compensation as exemplary damages in a proceeding under Article 32 by this court or under 226 by the High Courts for established infringements of the indefeasible right guaranteed under Article 21 of the Constitution is a remedy available in public law and is based on the strict liability for contravention of the guaranteed basic and indefeasible rights of the citizen. The purpose of public law is not only to civilize public power, but also to assure the citizen that they live under a legal system which aims to protect their interests and preserve their rights. Therefore, when the court molds the relief by granting compensation in proceedings under Article 32 or 226 of the Constitution, seeking enforcement or protection of fundamental rights, it does so under the public law by way of penalizing the wrongdoer and fixing the liability for the public wrong on the state which has failed in its public duty to protect the fundamental rights of the citizen. The payment of compensation in such cases is not to be understood as is generally understood in a civil action for damages under the private law, but in a broader sense of providing relief by an order of making monetary amends under the public law for the wrong done due to the breach of public duty of not protecting the fundamental rights of the citizen. The compensation is in the nature of exemplary damages awarded against the wrongdoer for the breach of its public law duty and is independent of the rights available of the aggrieved party to claim compensation under the private law in an action based on tort through a suit instituted in a court of competent jurisdiction or and persecute the offender under the penal law. In the case of Subhay Singh versus State of Haryana, reported in 2006 Volume 3 SCC, page 178, their Lordships of the Honorable Supreme Court have held that it is well settled that award of compensation against the state is an appropriate and effective remedy for redress of an established infringement of a fundamental right under Article 21 by the public servant. It has been held as follows. It is thus now well settled that award of compensation against the state is an appropriate and effective remedy for redress of an established infringement of a fundamental right under Article 21 by a public servant. The quantum of compensation will, however, depend on the facts and circumstances of each case. Award of such compensation by way of public law remedy will not come in the way of the aggrieved person claiming additional compensation in a civil court in enforcement of a private law remedy in tort now come in the way of a criminal court ordering compensation under Article 357 of the Code of Civil Procedure. My lord, this next paragraph is relevant for the petitioners I represent. In the present case, the boy had a life to live under Article 21 of the Constitution of India. Healthy and happy life has been curtailed by the criminal neglect of the respondents, causing him serious and painful burn injuries. He has to live with the trauma and remain handicapped through the life. The petitioner has to go through inconvenience, hardship, discomfort, disappointment, frustration, and mental stress throughout his life. On the basis of this, my lord, from paras 45 onwards, the basis for compensation is there. And ultimately, my lord, the compensation that is ordered, my lord, is at page 62.
Your friend will get a heart attack.
Supreme Court reduced it to 90 lakhs. Page 62, my lord, at the bottom of the page, para 49.
Page 62.
62.
Now here they discuss pecuniary and special damages.
Yes, my lord. In both of the cases, my lord, it's pecuniary and non-pecuniary damages.
Pecuniary is the actual expenditure.
Yes.
Yes.
As far as pecuniary, my lord, the medical and the loss of earnings. And for non-pecuniary, the damages for mental and physical shock, pain and suffering, loss of amenities of life, 3, loss of expectation of life, and 4, inconvenience.
Page?
This is in the Supreme Court judgment. I'll point it out.
Yes.
Actually, my lord, I just pointed out right now. It's at para 45.
Para?
45, page 52. Can I read para 45, please?
Yes.
Their lordships of the Honorable Supreme Court in the case of R.D. Attangadi versus Pest Control India Private Limited, reported in 1985, Volume 1, SCC 551, have laid down the following principles to determine compensation for visit. Broadly speaking, while fixing an amount of compensation payable to a victim of an accident, the damages have to be assessed separately as pecuniary damages and special damages. Pecuniary damages are those which the victim has actually incurred and which are capable of being calculated in terms of money, where non-pecuniary damages are those which are incapable of being assessed by arithmetical calculations. In order to appreciate two concepts, pecuniary damages may include expenses incurred by the claimant, 1, medical attendance, 2, loss of earning of profit up to the date of trial, 3, other material loss. So far, non-pecuniary damages are concerned, they may include damages for mental and physical shock, pain and suffering, already suffered or likely to be suffered in the future, damages to compensate for the loss of amenities of life, which may include a variety of matters, that is on account of injury, the claimant may not be able to walk, sit or run, damages for the loss of expectation of life, that is on account of injury, the normal longevity of the person concerned is shortened. 6, therefore, inconvenience, hardship, discomfort, disappointment, frustration, and mental stress is there. The lordships of the Honorable Supreme Court in the case of Rekha Jain versus National Insurance Company Limited, reported in 2013, 8 SCC 389, have reiterated the following principles for granting compensation for personal injury. It is a well-settled principle that in granting compensation for personal injury, the injured has to be compensated, 1, for pain and suffering, 2, for loss of amenities, 3, shortened expectation of life if any, 4, loss of earnings or loss of earning capacity, or in some cases for both, and 5, medical treatment and other special damages. In personal injury cases, the two main elements are personal loss and pecuniary loss. Chief Justice Cockburn in Fair's case distinguished the above two aspects thus. In assessing the compensation, the jury should take into account two things. First, the pecuniary loss and the plaintiff sustains by the accident. Secondly, the injury he sustains in his person or his physical capacity of enjoying life. When they come to the consideration of the pecuniary loss, they have to take into account not only his present loss, but his incapacity to earn a future improved income. So, my lord, on that basis, at para 49, my lord, the heads at page 62, Now we have to award the just and fair compensation. As
49.
49, paragraph 49. Now we have to award the just and fair compensation as per the principles laid down in the judgment cited above, taking into consideration the 100% disability of 8 years old boy at the time of electrocution. According to the evidence made in the petition, he was a brilliant student. The petitioner normally had started earning at least rupees 30,000 per month after attaining the age of 20 years. His life expectancy can safely be taken as per the prevailing trends to 70 years. He would have safely worked for 38 years. The appropriate multiplier in the present case would be 25. There is no possibility of marriage of the petitioner, therefore no standard deductions can be made for the income. The income in entirety has to be taken into consideration. The annual income of the petitioner would be rupees 3,60,000, which is required to be multiplied into 25. The total future loss of income of the petitioner comes to 90 lakhs. The petitioner is also entitled to standard damages of rupees 10 lakhs towards loss of companionship, life amenities, pleasures, and loss of happiness. The petitioner is entitled to rupees 10 lakhs of pain and suffering, including mental distress, trauma and discomfort and inconvenience. He is entitled to rupees 10 lakhs towards attendant nursing expenses for his life. He is also entitled to a sum of rupees 5 lakhs for securing artificial robotic limbs and future medical expenses. The writ petition is allowed, and in order to secure financial amenities for future of the petitioner, the respondents 2 and 3 would pay compensation of rupees 1 crore 25 lakhs. So when this, my lord, was carried in appeal to the Honorable Supreme Court, over the page, my lord, page 64. At page 65, my lord, para 3, is a short summary of the accident itself. On 18/3/2012, at about 3:30, the respondent Naval Kumar alias Rohit Kumar, who was 8 years old at the time of the incident, accompanied his mother in the fields to collect saag, vegetable, where he got electrocuted with a high tension wire, 11 kV, commonly known as the Daru Chawari lane. He received grievous burn and other injuries and became unconscious. FIR has been registered. My lord, may please see para 14. On the liability matter. The High Court held, and in our view, rightly. Can I read that, please?
Yes.
The High Court held, and in our view, rightly, that the incident in question occurred due to the negligence of the state and its authorities, and hence the state was vicariously liable to compensate the respondent for the losses sustained by the respondent. It may be mentioned that the state rightly did not challenge this finding, and hence it did not hold its correctness. The High Court held, in our view, rightly, that having regard to the family background of the respondent and for the respondent's excellent performance as a brilliant student in studies, he would have easily earned rupees 30,000 per month in his life. We have no ground to interfere in this finding of fact, which in our opinion is based on proper material on record.
There's only one thing. There is a difference in saying that they are negligent. It's of no relevance if you take the first principle of strict liability of bringing a dangerous thing in. That's one part. Only if you go to your 2010 regulation and that the circuit breakers didn't work, then the question will come up.
That's the difference. In the petitions, there's no question of that, my lord. Both of them got electrocuted. One above the horse, the other child in the line was just past the balcony.
So they came in contact with the line.
Yes, my lord. And the first child, my lord, the 7-year-old boy, he doesn't even come in contact. The high tension wire, it's not at the relevant height. So he comes within what's known as the arcing zone. And he serious injuries to that child.
That report of the electrical inspector is the same.
Both cases, there are reports of them. I'll go to the facts when my lord.
Yes.
Para 15 may please be seen.
Yes.
The High Court, however, further awarded rupees 10 lakhs towards loss of companionship, life amenities, pleasure and happiness, rupees 10 lakhs for pain and suffering, mental distress, trauma and comfort and inconvenience, rupees 10 lakhs towards attendant nursing expenses, and lastly rupees 5 lakhs for securing artificial robotic limbs and future medical expenses. In our considered view, the award of compensation under these 4 heads appear to be on a very higher side and is not supported by any evidence. It is, in our view, based on assumptions and presumptions to which we do not concur. In our view, entitlement under these heads is one thing, the quantum of grant of compensation under these heads is another. In this view, in this case, as rightly urged by the learned counsel for the appellant, they state the lump sum award of compensation under these heads is on the higher side and it is not supported by any evidence. It is therefore not legally sustainable. In our considered view, taking into consideration the facts and circumstances of the case, such as the respondent's family background, his age, nature of permanent disability suffered by the respondent, performance in studies, determination of monthly yearly income made by the High Court, expenses incurred, and all the relevant factors which are usually taken into account in awarding compensation to the victim, the respondent is held entitled for a lump sum compensation of rupees 90 lakhs. This is what the Honorable Supreme Court orders, madam.
It's a 90 lakhs.
Please. From 1 crore 25 lakhs to 90 lakhs.
Yes.
Similarly, is the judgment at page 69, Raman versus Uttar Haryana Bijli Vitran Nigam Limited. Can I please read, my lord?
Yes.
Page 74, please. Page 74, my lord. Para 2.
Yes.
The brief facts are stated herein. The appellant, a 5-year-old boy, was electrocuted on 3/11/2011 by coming in direct contact with a naked electric wire lying open in the roof of his house. Immediately after the incident, the boy was taken to first aid to nearby so-and-so hospital in Panipat, Haryana, and there he was referred to Postgraduate Institute of Medical Sciences, Rohtak. The final treatment was given at Safdardjung Hospital, New Delhi, where the doctors left with no other option but to carry out triple amputation by removing both his arms up to the armpit and left leg up to the knee, as previous injuries suffered were not curable. On 8/2/2012, the disability certificate was issued to the appellant certifying of 100% permanent disability. Lord, may please see para 4 over the page. The appellant approached the High Court by filing a writ petition under Article 226 of the Constitution of India for award of compensation from the respondents on account of negligence on the part of the respondents, which resulted in the tragic electric shock leading to triple amputation of the appellant. The said writ petition was opposed by the respondents by filing a written statement denying the allegations made therein, stating that the iron angle found on the roof of the house was not installed by any employee of the respondent electricity department. It was stated by the respondents that the father of the appellant was to be squarely blamed for installing the insulator himself on the roof of the house, on which high tension wire was erected to keep it at bay so as not to touch brick and mortar. Therefore, neither the first respondent, Uttar Haryana Bijli Vitran Nigam Limited, nor can its employees be held responsible or accountable for the mishap occurred on the fateful day, much less the damages or monetary compensation to be awarded in favor of the appellants herein. The learned single judge of the High Court adverted to Section 68 of the Electricity Act 2003, Rule 91 of the Electricity Rules 1956, which laid on the procedure of safety and protective devices provided for overhead electric lines erected over the part of the street or public places or any consumer premises, and mandate that they should be protected with a device approved by the inspector for rendering the line electrically harmless in case it breaks. The learned single judge of the High Court further referred to Rules 29, 44, and 46 of the rules, which are statutory in nature and which require the Electricity Authority to conduct periodic inspection of the lines maintained by them and to take all such safety measures to prevent accident and maintain the lines in such manner that life and property of the general public is protected. The learned single judge has considered the position of law declared by this court in a catena of cases for awarding compensation, particularly the electrocution cases, and held that the principle of strict liability and consequential negligence in awarding compensation in favor of the claimants against the State Electricity Board. This court and various other high courts, such as the High Courts of Madras, Madhya Pradesh, Orissa, Kerala, Gujarat, have awarded compensation to victims of electrocution in exercise of extraordinary and appellate jurisdiction, and have held the Electricity Board supply companies are duty bound to take protective precautionary measures under the provisions of the Act. Therefore, The learned judge had held that the electricity authority, the first respondent, to be liable to pay the compensation to the claimant, irrespective of the fact that the harm could have been avoided by the consumer by taking precautionary measures. The learned single judge of the High Court has referred to various judgments of this court as well as the aforesaid High Courts rendered under the Motor Vehicles Act determination and awarding justice compensation in favor of the claimant, which are, and by applying the multiplier method as specified in the schedule to the Motor Vehicles Act. The learned judge, the single judge, awarded compensation to the appellant and issued directions. In this, my lord, one of the directions was that one part of the compensation will be deposited in an account and interest will go to the child. And in the event the child doesn't survive, then it will revert back to the state. So that only that one direction has been set aside in this High Court order. In this, it was a 60 lakh rupees compensation that was granted. My lord, may please see also paras 15, 16 and 19. 15 is at page 79. Having regard to the age of the boy as 5 years at the time of incident and longevity of life of the Indian citizen as 70 years, the remaining 65 years the appellant is required to suffer from mental agony and hardship. He is virtually deadwood and further he has to undergo continuous pain and suffering at the time of attending the nature's call, sitting, standing, walking and sleeping. He has to face difficulties in all walks of life, which is worse than death. His childhood is lost, the marital status and happiness is lost, which cannot be compensated in terms of money. He has to undergo great ordeal and agony throughout his life. He requires a permanent attendant throughout his lifetime and to assist him for all purpose and to whom the appellant is required to pay minimum at an average of rupees 10 to 15,000 per month. And it is a hard reality that the cost of living in our country is also steadily increasing day by day. This aspect of the matter should have been taken into consideration by the division bench of the High Court at the time of reducing the compensation amount. The learned, I'll just read this next paragraph. The learned single judge of the High Court has awarded compensation keeping all these aspects of the matter and has applied the guiding principle of multiplier method after adverting to the case in Sarla Verma versus DTC for the purpose of computation of just and reasonable compensation in favor of the appellant, which method should not have been applied to the case on hand, particularly having regard to the statutory negligence on the part of the respondents in not providing the safety measures to see that live electric wires should not fall in the roof of the building by strictly following the rules to protect the lives of the public in the residential area. This court in Balram Prasad versus Kunalsa has deviated from following the multiplier method toward just and reasonable compensation in favor of the claimant in a medical negligence case. The same principle will hold good in the case on hand. So in this, my lord, what the court finally does is at para 19. Sorry, my lord. Para 21, my lord, page 85. Page 85. In view of the law laid down by this court in the aforesaid cases, which are extensively considered and granted just and reasonable compensation, in our considered view, the compensation awarded at 60 lakhs in the judgment of the learned single judge of the High Court, out of which 30 lakhs were to be deposited jointly in the name of the appellant, represented by his parents as natural guardian and the chief engineer or his nominee representing the respondent Nigam in a nationalized bank in a fixed deposit till he attains the age of majority. It is just and proper, but we have to set aside portion of the judgment of the learned single judge, directing that if he survives, he is permitted to withdraw the amount. Otherwise, the deposit amount shall be reverted back to the respondents as the same is not legal and valid for the reasons that once the compensation amount is awarded by the court, it should go to the claimant appellant. The first part of the whereas a particular portion is actually put into a fixed deposit, so that interest that accrues will actually help in the upkeep of the child on a monthly basis. I would kindly request, my lord, that aspect, my lord, may be kept in mind in the event, my lord, this honorable court deems fit to allow the petition.
Where is that direction?
It's at the directions of the single judge. It's at page 76. para 8. It's extracted in toto, my lord, in the Supreme Court judgment. Page 76, para 8. Can I read, my lord? In order to secure the final, I'm reading from para 41.5. In order to secure the financial and monetary future of the minor Raman, it is directed that the respondent Nigam would pay compensation of 60 lakhs to him immediately for loss of enjoyment of life trauma suffered and to act as a guard against neglect and dependence on others, loss of future employability, and the agony of it all, pain and mental shock suffered and continue to be suffered by an irreconcilable event that has completely changed the life of the family. This amount would be made available with interest on reaching the age of 21 years, act as a financial security and building block for the future. The amount will be deposited in a fixed deposit account in the name of the petitioner and the joint guardianship of the parents of Raman and the engineer or his nominee representing the respondent in the bank, preferably in State Bank of so-and-so. The amount is directed to be deposited within 60 days of receipt of certified copy of this order, failing which the amount will carry 8.5% interest till deposit in the bank, whereafter the principal amount will earn interest at bank rates for fixed deposit fixed from time to time. However, the amount awarded under this act will only be made available to minor Raman on attaining age of majority 21 years. In case the minor Raman does not survive till the age of majority, this amount with all interest accrued shall revert to the respondent Nigam with no claim on it by any third party or the parents of the siblings of Raman. This would ensure that the child is valued and cared for till its majority. So that second part, my lord, where it will revert, that has been set aside by the Honorable Supreme Court.
Continue. We'll continue next Friday. Next Friday.
Next Friday.
Just matter for further arguments on 10. It will come up higher up in the list. At the end, you'll have to give a brief of what paragraph number, etc. Is there? You can find. So whatever pleadings you want, you can file. Yes. Wait for it. Friday, Devraj will be there.
We can accommodate morning.
Afternoon. Division. Otherwise, Tuesday in the post lunch. Tuesday. Our service matters coming. Our service matters coming. Our service matters coming. So 7.
One mention.
Yes.
Matter is serial number 36 by law and connected matters.
Yes.
This matter concerns petitioners who have received the salary for 10 years. Unless we would like to press on I for certain direction. My lords could kindly have it listed next week, preferably on Wednesday, my lords. 36 connecting matter. WP 11558 of 2019, WP 57295 of 2018. I'm appearing for the petitioners, my lord.
This date will be assigned. Huh? That same matter. Next 15. Other dates, if you want, you can ask the court office.